The learned counsel appearing for the accused applicant submits the serious instructions to withdraw the instant case. The matter is dismissed on withdrawal.
Please, Your Worship. I recommend item number 28.
Yes.
As per instruction, allow me to withdraw this petition because as per instruction, final report had submitted in this case.
Mr. S. Islam, the learned counsel appearing for the accused applicant, needs the his instructions to withdraw the instant AB application. Also, the matter is dismissed on withdrawal.
Obligers.
May it please your Lordship. Lordship, I beg to mention item number 32, Lordship. Lordship, the case diary is not received yet. Lordship, I also pray for extension of the interim order.
Case diary is awaited. Interim order so far struggles shall continue in the next date of listing. Let the matter be listed on 24th June.
Much obliged.
Please, Your Lordship. Recommended item number 22, Lordship. Item number 23.
23.
Kindly adjourn the matter to the day, Lordship. Matter will be taken after vacation, Lordship.
It's a bail hearing.
Yes, Your Lordship.
Why after vacation? We cannot
See, rules out.
bail hearing were pending for such a long time. Can't be done.
After 2 weeks, sir.
No, can't be done for such a long time. TCR has come already.
Yes.
The schedule is
Come.
out of session, Lordship.
And that bail matters cannot be kept pending for such a long time. Criminal revision, criminal appeal is a different thing. Bail matters cannot be kept like this.
Sorry,
On the prayer of law in the council, your name?
yes, good.
MSS Upam. Let the matter be listed in the next week. It is next week. No, let the matter be listed on 23rd June. 23rd June.
May I please, Your Lordship? Item number 24. Due to the personal difficulty of the engaged advocate,
Who's
the
engaged?
TK Mishra.
Hmm?
TK Mishra.
There are so many other people are there. There are four other councils are there.
Yes, he is looking after the case.
Hmm?
He is looking after the.
What other people are doing then?
He is
Other
the
people are not
yes.
looking into the case.
only he is the senior.
What is your name?
S Jamal.
Hmm?
S Jamal.
You also there in the case. You do the case.
No,
5 people are there in the bail matter only. On the prayer of Mr. S. Jamal.
We have received the case there.
Preparing for the people's applicant. Let the matter be listed on. 16th.
Worship, the matter will be taken up at 2 p.m. The matter will be taken up at 2
16th, we are fixing 16th.
16.
1/6. 16th, we are fixing the matter.
But please, Your Lordship, I beg to mention with item number 20. My lord, due to some personal inconvenience, the engaged counsel could not come for today, my lord. May it be after the vacation.
We are appearing for whom?
I'm appearing Mr. T.R. Sharma.
Lordship, I am appearing.
Does it also
Lordship,
inform
Okay, on the prayer of MS, your name?
and Kalita?
And Kalita appearing on behalf of Mr. T.R. Sharma. Let the matter be listed after 2 weeks.
Lordship, I am for the response number 3.
The council, Mr.
Kindly fix it on 25/6.
Mr.
RK Mohanto.
Monto appears for respondent number. Respondent number?
3, Lordship.
Respondent number 3. Let the matter be listed on
Lordship, I pray for a date 25/6, Lordship.
25th. Let the matter be listed on 25th. Both. 20 and 21. To be listed on 25th.
25/6. Obliged.
May please the Lordship. Lordship, I'd like to mention item number 18.
Item number?
18.
Hmm.
Lordship, may kindly adjourn the matter for today.
MSN Begum, the learned counsel, appearing to the petitioner, submits the petitioner case for adjournment of the matter. When do you want it?
Lordship, after vacation.
Case for adjournment of the matter. You are appearing with the other side?
Yes.
Your name?
And go it.
So N. Gauhati appears for the respondent number 1. I'll let the matter be listed after the ensuing vacation.
Lordship, interim may kindly be extended.
Interim order so far struggles shall continue till the next date of listing.
Much obliged.
Sorry.
Lordship. Lordship, I beg to mention item number 44, Lordship.
Yes.
The item may be adjourned for the day, Lordship. We need some time for preparation.
Hmm?
The item may be adjourned for the day.
Why?
We need some time for preparation and some instructions to be obtained as to the.
Listen, I mean, the matter is listed.
Yes, Your Lordship, on the last occasion, we were asked to obtain instructions as to the status of the petitioner as she is in detention, Your Lordship. So that could not be obtained as of date, Your Lordship, from the local council. That's why we need some time.
On the prayer of Mr. The learned counsel appearing to the applicant, let the matter be listed after 2 weeks.
I'm obliged, Lordship.
Interim was there.
No, Your Lordship. Lordship, another pair, bail application, Lordship, supposed to be listed today but could not be listed.
No, go to the registry.
Obliged.
May I please assume?
Yes.
My lord, an order is under basically challenge, my lord. The order, my lord, may be pleased to find is at page 23, annexure 3, my lord. A nature of serious allegation of manufacturing a document in my name, my lord, and a power of attorney had also been executed and land had been, my lord, the FIR, my lord, is at page 19, annexure 1, my lord, basing on which this order had been issued, my lord.
So what happened actually?
My lord, this is an FIR
Hmm.
lodged by me as an informant, my lord. My signature, my thumb impression, my lord, had been forced by this accused, my lord. And basing on this FIR, my lord, the Sangsari PS case has been registered. And basing on this, my lord, FIR, he seek for an pre-arrest bail at, my lord, page number 23, annexure 3, is the order by which, my lord, the learned court below, my lord, without even going for the call for the case diary, an absolute bail had been granted. Now, my lord, we are before my lordships with an application for cancellation of the bail, my lord. That is the limited, my lord, because this person is an habitual offender. If my lordship may be pleased to peruse, my lord, the paragraph 5 of my petition at page 8, my lord, kindly see the nature of criminal activities of this person, my lord. Altogether, 7 numbers of cases is already pending, my lord. This is the another one. Page number 5 at page 8, my lord. And this is criminal, my lord, and in the next page, this is in the nature of civil also, my lord. I am also one of the victim of the such type of forced activities, my lord.
Okay, we'll call for.
My lord, my lord.
Third, we have the next counsel assistant.
My lord by S. Abdullah, my lord.
So yes, to install. So what is VP Swami, the learned ATP policy is an application on the of BNSS, which is paying for cancellation of PRS bill transfer by the learned. System just look. I mean, right in order to 11/2026, asking AB number 1092026 in favor of respondent number 2. In favor of respondent number 2, namely Papan Mali.
Party bonus, huh?
Let notice be issued on respondent number 2 to speed post. Returnable on 25th. Mr. Goswami, 25th, returnable on 25th June. Call for the CD. Later matter fixed on 25th June.
My lord, the
No,
respondent,
we'll go to respondent number
respondent to also, my lord, by registered post.
by speed post.
Mal. Obliged, diploma.
Please, your lordship. Lordship, in this matter, the petitioner has been arrested by the Bijni PS on police station on 16/5/2026. The FIR is at page 12. On that, on 15/5/2026, an accident occurred. Wherein the petitioner was driving a vehicle, four-wheeler vehicle, and he hit one scooty. Page 12 is the FIR. He hit a scooty and injured 3 persons. Out of that 3 persons, 2 persons died, and the third person is under has been hospitalized.
For the CD, Mr.
Yes.
Lordship, one thing just I want to show the observation. Page 20. Page 20. By this order, bail application was rejected. May I show? The case
What is there? What is there?
the statement of some material witnesses has already been recorded, as well as police has seized some documents also.
Yeah, it's good only. I mean, let CD come, then we can consider it altogether. Heard Mr.
27 days already behind the bar.
Heard Mr. D. Chaudhary, the learned counsel, appealing for the accused applicant. Also heard Mr. D. P. Goswami, learned appealing for the state. Is an application under section 483 of BNSS 2023, praying for grant of bail to the accused applicant in connection with Disney PS case number 64/2026 under section 281/125 in bracket small b /105 BNS. Call for the CD. Let the matter be fixed on 23rd of June.
Lordship. Much.
Wait, please, your lordship. Lordship, this is a regular bail application. In this case, this petitioner in jail custody for 38 days, lordship. FIR lordship will find on page 15, lordship. As per FIR lordship, he was taken by this petitioner lordship. No force has been mentioned in the FIR lordship. May I read the FIR first, lordship? It is respectfully stated that on 4/3/2026 evening at 7 p.m., the accused person took my husband, Abdul Mannan Bodbhuya, from our home to Gauhati. Thereafter, the accused number 1 and 4 went with their Scorpio vehicle bearing registration number such and such, and after reaching Gauhati, his mobile phone was found switched off and he could not be contacted. Though the wife of the accused number 1 lodged and missing entry, and even I also lodged and missing entry at Kaline PS. Subsequently, I have received a phone call from the accused person, wherein the caller demanded ransom amount of 10 lakhs. That is his lordship. But lordship, so far
Mr. B. Chaudhary, the learned counsel, appealing for the accused applicants. Also heard Mr. D. P. Goswami, learned APC for the state. Is an application under section 483 of BNSS 2023, paying for bail to the accused applicants in connection with client PS case number 28/2026. 2026 under registered under section 140 that stroke 3 of BNS for the city. Data material fixed on 25th of July.
obliged. Can it be lordship 24, lordship?
24th of July.
Hello.
May it please your lordship. Lordship, on the basis of an old video of 2024, lordship, an FIR was lodged, lordship, against 2 persons, lordship, not against the petitioner, lordship. Thereafter, lordship, the petitioner being the owner of a drug rehab center, lordship, the petitioner was arrested, lordship, and his rehab center was also sealed until further order, lordship. He's behind the bar for the last 8 years, lordship. Custodial 8 days, lordship. Custodial interrogation may not be required, lordship, in this case, because already inquiry has been constituted, lordship. It's an old video of 2025, Lordship. He is running a rehab center, Lordship.
Heard Mr. P. Bodoli, the learned counsel, acting for the accused applicant, also heard Mr. P. Pujusami, learned accused for the state. There is an application under section 483 of BNSS. Paying for grant of bail to accused applicant in connection with Busana Charlie PS case number 112/2026, registered under section 117(2). Stroke 127(4), stroke 251(2), stroke 3(5) of BNS 2023. Call for the city, let the matter be fixed on 23rd June.
23rd June, Lordship. Oblige, your Lordship.
That please, your Lordship. Lordship, this is regular bail application, Lordship. And FIR will file, Lordship, page number 12, Lordship. Apparently, Lordship want. Yes, 12, Lordship.
Heard Mr. F of the learned counsel, acting for the accused applicant, also heard Mr. G.P. Goswami, learned APB for the state. There is an application under section 483 of BNSS. 203, paying for grant of bail to accused applicant in connection with Chansari PS case number 121/2026 under section 61 in bracket 2, stroke 318(4), stroke 309(4), stroke 5 of it is 3 of BNS 2023.
That is, your Lordship, and criminal intention, Lordship.
3(5) it should be a 3 stroke while you're writing. Call for the CD, later matter fixed on.
Lordship, can short that, Lordship, it is from Polter.
22nd June.
22nd. Lordship, deeply obliged.
May it please your Lordship. This matter, your Lordship, the FIR is at page 9, typed copy. Your Lordship, basically the whole matter is that there were 3 boys who were in the flyover, overbridge, Kumar Bhaskar overbridge, and at night, and then the patrolling party came, and there was a small scuffle with the police, and these persons were arrested, your Lordship. And all the 3 boys were arrested. They were young boys, your Lordship. Petitioner is about 29 years of age. Lordship, will kindly see one thing. Basically, they have stated that there was a scuffle, but in the order of notice, your Lordship, it is very specifically stated that the one of the person there, he was basically involved in earlier in such matters. The present petitioner is not involved at all, your Lordship. This is what all throughout it has been stated. And your Lordship will kindly see page. Lordship will see page page and I declare.
We call for the CD, Mr. Manan, in this.
Only thing, this guy, the boy, your Lordship, young boy, already in
Yeah,
custody.
young boys are doing problems these days.
But there is nothing much, your Lordship. Even
I mean,
the
like,
section 109 may not be attracted.
attempt to attack the police personnel.
That is actually the person, Raju Sharma is actually the person who has done that.
We'll see, we'll give a short date.
Short date then, your Lordship.
Heard Y.S. Manan, the learned counsel, attend for accused applicants, also heard Mr.
Page and I.
Learned APB for the
You
state.
don't know how we
This is an application under section 483 of BNS 2023.
Resignation to now.
Praying for bail of the accused applicant.
No, Marco point.
She's applicant. Is applicant in connection with Gorolomuk PS case number 68/2026 under section 1296. Stroke 132, stroke 109, stroke 121, bracket 2, stroke 5 of BNS to call for the CD. Let the matter is fixed on 22nd. 22nd. The boys are young, but parents are mature.
That is true, your Lordship. But still not that type of a person. Next item also I am appearing. Your Lordship. In this matter, basically item number 7, your Lordship will find the FIR at page 8, Here, your lordship, in fact, there is no offense committed as such. I have a prayer that he may be allowed to go in. Then there are technicalities here, your lordship. Basically, first and foremost, from the FIR itself, it seems there's no offense committed. He was arrested while he was at the shop. They said that he wanted to give them a loan, and there was no loan taken, nothing was done. So there's no transaction as such, your lordship, number one. Therefore, your lordship,
He was arrested.
he was arrested from that shop.
That's all. For how many days?
The two other persons have, your lordship, as per the FIR, two other
How many
persons ran
days?
away.
They are behind the bars.
8 days.
8 days.
8 days. And one more thing, your lordship, basically, the person was also not required by the police for your lordship interrogation also. That I will show your lordship. Turn to page 16, 16. He's been sent to judicial custody. 16, page 16, your lordship will see in the grounds of arrest, your lordship, the last para of grounds of arrest.
Yes.
Your lordship will say, unless the accused persons are arrested, their presence in court, whenever required, cannot be. Under the above circumstances, the accused person has been arrested and hereby forwarded to the honorable court with a prayer to remand him to judicial custody for a period of 14 days. This is in the remand order. So ultimately, he was by the next page 17, he was remanded to judicial custody. So in fact, your lordship, basically the police even don't want him for interrogation also. So at this stage, your lordship, my humble prayer, he may be granted, your lordship.
Yes, Goswami.
Only thing is that the grounds for there for the custody interrogation of the accused is required for recovery of seizure of false documents, electronic devices and communication.
But he's already there for 8 to 8 days. 8 days. What have you been doing for the last 8 days? Let him go. Nothing is there. Heard Mr. Y.S. Manman, the learned counsel, appearing for the accused applicant, also heard the D.P. Goswami, the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Office of PS case number 180/2026. The section 61, 2, P18/4/62, 336, 3, 5 of BNS. An FIR was lodged on 3/6/2026 by one Suhail Ahmed, alleging that the accused person with certain false assurances and using certain fake documents wanted to provide a loan facility to the informant. When the informant intimated the police came and arrested him. The accused applicant was forwarded, was presented before the Chief Judicial Magistrate, and he on the very same date, that is on. It is on 4/6/2026. He had been remanded to judicial custody, and since then he is inside the jail. So the learned Mr. Manan, the learned counsel, according to the accused applicant, submits that he's already 8 days he has spent behind the bars, and there is no offense has been committed by the accused applicant as could be seen from the FIR itself. He submits that there may not be any more custodial detention of him in the instant case. Therefore, he should be granted the privilege of bail. Full stop. Mr. D.P. Goswami, the learned APP, however, opposes the prayer of bail. Full stop. This court, after considering the entire facts, as well as taking into account that he is already behind the bars for us, it is of the considered opinion that the applicant should be released on bail. Accordingly, it is directed that the accused shall be released forthwith from jail on furnishing of bail bond of rupees 20,000, which is of like nature to the satisfaction of which court?
CJM Kamrup
Metro, subject to the condition that the accused applicant shall cooperate with the investigation and make himself available as and when required by the investigating officer. Then secondly, right, the accused applicant shall not try to influence any evidence or witness as may be involved in the instant case. In view of, in the above terms, the instant VA application is disposed of.
Obliged.
My lord, kindly take it up after some time, my lord. Kindly take it up after some time. Mr. Chaudhary will appear, my lord. He is on lake, my lord.
After some time.
Page 19 is the FIR, my lord. This is an pre-arrest bail, my lord, registered under section 1182, my lord, 74-296, my lord. FIR, my lord, will find it page 19.
19 or 12?
19, my lord.
12 is what?
12 is, my lord, will be the translated copy, my lord, type and translated copy, my lord. It's better to read, my lord, the original one, my lord. It's written in Assamese, my lord. Even though it's 1182 is there, I have carefully gone through the FIR, my lord. If my lord
You
wants-
read the FIR.
Yes, my lord. আজি ইংৰাজী 31-5-2026 তাৰিখে আবেলি সময়ত গড়হিমুখ গাঁৱত তেজপুৰ বিশ্ববিদ্যালয়ত যোৱা লিচু বাগান ৰাস্তাত মাৰপিট কৰে কিছুমান মুছলিম সম্প্ৰদায়ৰ লোক লগত গড়ত প্ৰৱেশ কৰি মহিলা লোকক লগত মাৰপিট কৰে মাৰপিটৰ কাৰণত দুজনী মহিলা আৰু এজন ল'ৰা গুৰুতৰভাৱে আহত হৈছে মাৰপিটত এক জাতিভেদ ভাৱ হিচাপে হিন্দু মানুহক লক্ষ্য কৰি কুবাক্য প্ৰচলিত কৰি এক কাজিয়া সৃষ্টি কৰে ইয়াৰ উপৰি কনকলতা চিকিৎসালয়ত মুছলিম মানুহ সোমাই মেডিকেল কৰিব যোৱা লোকক উভতি ধৰি মাৰপিট কৰে this is the allegation my lord will find there is no date and the time mentioned as far as this allegation goes, my lord, it is registered under section 182.
No, the date is there, 31-202.
35 the Azi. There in the FIR, my lord, date is
31.
Azi Tarikh, my lord. And then time Abeli, my lord, it's not there. Specifically, I'm not on technical ground, my lord, as far as allegations and ingredients of 1182 is not there. Gurutor Ahato means it's not there, my lord. It's at the best, my lord, will come 117 or 112, my lord. In that case, it is up to 7 years punishment because the weapons, there is no mention of weapons. And more importantly, my lord, the 74 is only 1 to 5 years punishment, my lord. 296 is 3 years punishment, my lord. Now, whether this 118 ingredient is there or not, my lord, two documents that I like to demonstrate, my lord, that police while forwarding the other accused, my lord, initially, page 23, my lord, in paragraph 3 and 4, during the investigation, it has also disclosed that active participation of the accused in the occurrence, my lord, those who have been arrested and forwarded to the custody, my lord. And now, the second line, my lord, the medical documents collected during the investigation substantiate the allegation of assault and injuries, my lord. Here also, grievous injury part is not there, my lord. What I am trying to demonstrate, my lord, in the FIR, grievous part is not there. Meaning thereby it's a case of 117, my lord, which is up to 7 years punishment, my lord. And sudden provocation part, my lord, our FIR, my lord, would find at page, even though I have not confirmed when it has been registered, my lord, 26 and translated copy, my lord, it basically a business quarrel, my lord. I'll go to demonstrate, my lord. I am basically a leasing businessman, my lord. Because of the season, my lord, one of the customer has approached them. I presume that it is my customer only on that count, my lord. This FIR has been lost, my lord. And the people was involved.
Call for the city.
At this stage, my lord, my respectful prayer will be, my lord.
No interest.
My lord, it's not a case of 118, my lord, as far as FIR goes, my lord.
No interest.
My lord, my respectful prayer to be whether the custodial.
Mr.
Yes, the person, my lord. My lord, my respectful prayer will be to consider, my lord, my submission, my lord.
Mr. DP Goswami.
Whether the custodial interrogation in this case is required or not, my lord.
We'll see.
My lord, first
Let
FIR
the
is there,
city
my lord.
come.
Only-
We'll give a short date. We'll.
My respectful
give
prayer
you-
will be some
We'll give you a
protection.
short date. Don't.
I am a leading businessman, my
We'll
lord.
give you a short date.
Please consider my interim prime, my lord, at this stage. Prima facie, my lord, it's 118 is not there, my lord.
Granting 2 years bail to the accused How many people are there? Two.
I'm not the main accused, my lord.
No, you were two before this court.
Yes, I am for two, my
Those
lord.
applicants in connection with S2 PS case number 283 stroke 2026 registered under section 74 stroke 118 bracket 2 stroke 296 stroke 35 of VNS. VNS call for the CD, let the matter be fixed on 23rd. We are posting it.
My lord, my respectful prayer will be to consider some protection, my lord, at this stage.
We'll go through the CD and will, if no materials are there, you'll get the privilege.
As far as FIR goes, my lord, 118.
There are allegations. There are allegations.
I'm deeply obliged, my lord. I'm deeply.
May I please, your lordship? Lordship, I have instruction from my client to withdraw this case, please.
11, I think already mentioned, isn't it?
11, 12.
Item
Lordship,
number 11.
11 is mentioned.
Lordship, 11 I have mentioned, but they are the withdrawal number 8, Lordship.
Huh?
Number 8 also we have in the matter, but they have
Number 8,
মই 11 mention কৰিছিলো তেওঁলোকে
8 you have mentioned.
no 11
11 is
mentioned.
mentioned.
So wrongly mentioned.
Yes, 11 I have mentioned, Lordship.
You want to withdraw which item?
11.
And what about 8?
8 we have continued, Lordship.
8 you are mentioning for adjournment.
No, Lordship. We have
So 8 has already been mentioned by you.
11 I have mentioned, Lordship, for withdrawal.
Okay, we'll take item number 8 after some time then. Okay.
Okay.
The 11 we were withdrawing.
Yes, Lordship.
Okay, item number 11 you read. You already written, no? Okay. Yes, madam.
May I please your lordship?
Hmm.
Lordship 482 application. And
Where is the FIR?
FIR lordship relevant portion page number 11 to 13 lordship. 12 is the main lordship. Allegation is that the petitioner threatened the informant and demanded rupees 2 lakhs from the informant lordship.
The complaint has been filed by whom?
Complaint is filed by the informant lordship, who is the husband of the petitioner lordship. And the petitioner is the first wife of the informant.
Who?
Petitioner lordship. First wife of the informant.
So the money is demanded by whom?
Money allegation is that money is demanded by the petitioner wife lordship, and they have mutually agreed to separate live separately lordship, and thereafter they live separately, and as there was a mutual agreement between them that the informant will pay rupees 15,000 for the maintenance of their child, only child, lord. But thereafter the informant refused to pay the money lordship, and hence
that's why you have demanded the money.
Demanded money lordship. I am asking for the maintenance lordship, and petitioner informant has lost this false case lordship against me lordship.
Page 12 of the complaint lordship. Para 3 and 4.
Para 3 and 4 lordship.
May I read lordship?
Lordship, I am the wife lordship of the informant lordship. And she has
Kuswami, what is that?
lordship, interim protection
Made to another person. That's why. Okay. As per the paragraph 3, that subsequently after some months, the petitioner came to know that the respondent number 2 was already married to another person.
No, my lord. I have not married lordship. He had married.
Yes, sir. As per the complaint.
Second time.
Lordship then.
Heard MS G. Deka, the learned counsel, appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APP for the state. This is an application of the section 42 of BNSS 2023, paying for pre-arrest bail to the accused applicant in connection with Romania PS case number 104/2026 under section 329 in bracket 4 stroke 308 bracket 2 stroke 351 bracket 2 stroke 318 bracket 2 of BNSS 2023. And when FIR was lodged on 23/4/2026 by one Nimble Devnath, alleging inter alia that his wife, after being separated, got married to some other person without being divorced, and thereafter started blackmailing and demanding money from him. It was alleged that the accused applicant came to the petitioners, came to the informant's shop and created disturbance and threatened the petitioner with dire consequences if her demand of ₹2 lakhs is not met with by the informant. In view of the aforesaid FIR, the police registered Romania PS case number 104/2026 under section 329 in bracket 4 stroke 308 bracket 2 stroke 351 bracket 2 stroke 318 bracket 2 of BNS 2023. The learned counsel appearing for the accused applicant submits that the accused applicant has not demanded any money from the informant, and in fact, both were earlier married, and after their separation, they have been staying separately. And on mutual agreement, the husband, the informant, that is the husband of the accused applicant, was paying her certain amount for the maintenance of their children. However, since he stopped paying the aforesaid amount, she has requested for payment of certain amount. Therefore, the learned counsel submits that there is no offense committed by the accused applicant in the instant case, and no custodial detention is required in the instant case. Therefore, she should be allowed to go on pre-arrest bail. Next by Mr. D.K. Goswami, learned APB, however, opposes the pre-arrest bail at this case. This court has gone through the materials for this court, and also after hearing the submissions made by the council appearing for special parties, is it considered appearing that the accused applicant should be granted a pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant in connection with Romania PS case number 104/2026, she shall be released on bail on punishing of bail bond of ₹20,000. 20,000 rupees at like nature to the satisfaction of the arresting authority, subject to the condition that number one, accused applicant this 18 number of the and in terms of the authorization, the instant AV application is disposed of.
Obligation.
May please, Your Lordship. This is a pre-arrest bail application. Finally, Peru's FIR is at page 9, Lordship. The mother-in-law and sister-in-law before Your Lordship, the husband has already been arrested, Lordship. Abatement of social. Lordship, the petitioner number one is a old age at lazy, Lordship. He is a 76 years old, Lordship. And petitioner number 2 is a mother of a two minor children, Lordship. At least I am praying for the interim, Lordship, for the old lady, Lordship.
No interim,
He is suffering from
no interim at all.
several ailment, Lordship. I have annexed the medical
No
document.
interim at all.
I have annexed the medical
Mr.
document.
D. Halder, Delaware Council appearing for the accused applicant also heard Mr. DP Goswami Learned APP for the state. He is an application under section 42 of BNSS 2023, praying for granting clearance bail to the accused applicants in connection with Longpa PS case number 72/2026 under sections 80/108 of BNS. All for the CD, let the matter be fixed on.
Lordship, may I pray for a short date, man? Kindly short date, Lordship. This is an old age,
23rd May,
Lordship.
23rd June. Very short date we have given. But we cannot give you interim with these kind of allegations.
Matter worship, my lord.
Yes.
One of the petitioner is the headmaster of the LP school, my lord.
Mm.
And he was not at all there in the place of occurrence. And page 16 is the FIR, my lord.
Please.
Page 16. It is a business tribunal, two groups of people, my lord. And one of my relation is involved in that case. That's why police is after me. My lord. Nobody is named in the FIR. My case is, my lord, stated in paragraph 4, page 4. That is from the
How you are involved?
Because two of my relatives are involved in this case, my lord.
Huh?
Two of the relatives,
Hmm.
they are involved in the case.
Hmm.
And one and two, my lord, and your
Why you are apprehending arrest?
because your lordship kindly say paragraph 4, I have stated details, my lord.
Hmm.
Paragraph 4. Because I was there, 2 kilometers away I reside, madam.
Hmm?
2 kilometers away I reside. I stay. And your kindly
But
paragraph,
what is your apprehension?
yes, kindly say, madam. Police has been my paragraph 4 middle person, madam.
Hmm.
It is further submitted that police have been visiting the residence of petitioner, causing unnecessary harassment and mental distress to him. Family members, thereby the petitioner got reserve apprehension. The petitioner categorically states that he is a completely innocent, has no involvement, he is being falsely indicated only because he is an educated person and happens to be distantly related to the accused person, with a mere suspicion that he might assist them in getting the legal aid, my lord. Only is the educated person in that area, my lord, you can say, my lord. And that's why your lordship kindly see the other things also, my lord. So far his involvement, my lord, I don't find because nobody is.
You are a school teacher.
School, yeah, headmaster of the school. Page, kindly see page, my lord. Page 11, my lord, page 11. Identity card. And wife is my lord, 7 months. Expected date is my lord, it is also given page 22. This is page 11, my lord. And 2 kilometers away he reside and school is also 2 kilometers away.
Anything also due to sage attack, he sustained several injuries
No, that's I am not aware because it is.
on head,
We-
eye, face.
Heard Mr. H.R.A. Chaudhary, the learned senior counsel, assisted by so and so.
SS Ahmed.
Also heard Mr. D.P. Goswami, the learned APD for the speech. This is an application under section 43.
Oh, no problem.
Versus 2023, claim for 3 years bail to the accused applicant in connection with Sri Bhumi PS case number 111/2026 registered under sections 329(4) stroke 189(2) stroke 117(2) stroke 118(2) stroke 109 stroke 304 of BNS. An FIR was lodged on on 20. FIR was lodged on 26.
My lord?
FIR was lodged when?
Yes. The FIR is lodged on 18/5.
18.
Occurrence is 16/5/26.
18/5/2026.
And occurrence 16/6.
By one,
16/5.
by one, or is it they? Alleging that on 16/5/2026 at about 10:30 PM, 10:30 to 11 PM, after closing his business activities while he was coming down from his shop along with one Piku Majumdar, the several persons in a group physically attacked both the informant and the aforesaid Piku Majumdar and snatched gold ornaments and cash approximately of ₹2 lakh. Full stop. That's semicolon. That due to such attack, both the informant and the aforesaid Piku Majumdar suffered injuries. Full stop. On register, after receipt of the FIR, the police registered the Sri PS case number 111/2026 under the aforementioned sections. Full stop. Mr. H.R. is audited the learned senior counsel submits that the accused applicant is nowhere associated or linked with any group which has attacked the informant and the aforesaid Piku Majumdar. Full stop. He submits that the accused applicant is a headmaster in a school who resides 2 kilometers away from the place where the incident had occurred. He submits that he is apprehending arrest because one of his relatives has been accused and has been accused and arrested by police in the instant case, and he being a relative, police is visiting his place also. Due to such apprehension, he has filed his instant PROCEEDINGS bill application. Now, Mr. H.R. further submits that he being a responsible citizen will cooperate with the investigation in the event of his release on pre-arrest bail. Full stop. The learned if Mr. D.P. Goswami, learned deputy, on the other hand, opposes the bill or opposes the prayer of pre-arrest bail for the accused applicant. Full stop. This court has gone through the materials before this court as well as heard the submissions made by the counsel appearing for the respective parties is of the considered opinion that the accused applicant should be granted PRS bail at this stage. Accordingly, it is directed that in the event of the arrest of the accused applicant in connection with Sri PS case number 111/2026, he shall be released on furnishing of a bail bond of rupees 30,000 with the security of like nature to the satisfaction of the arresting authority, subject to the conditions that the accused applicant shall appear before the investigating authority within a period of 10 days of passing of this order. Then number 2, the accused applicant shall cooperate with the investigation and shall make himself available before the investigating authority as and when called for. Number 3, accused applicant shall not try to influence any of the witnesses that may be connected in the instant case. In view of the in above terms, the instant application is disposed of. Dispose of, we have granted pre-arrest bail to you.
Obliged.
You will need some more, Mr. Chaudhary?
No, obliged, obliged.
Dispose.
My lord, here one petitioner before your lordship. My lord, before going to the FIR, my lord, I get to, my lord,
First, let me go to the FIR, Mr. Borgia. You don't need to submit anything more than that. Just show me that FIR.
yes, my lord. FIR, my lord, page 14.
Read out.
Yes, my lord. I respectfully beg to state that today on 9/5/2026 at 3:10 p.m. on receipt of a reliable source information as well as information communicated by superior officer.
Read little bit louder so that I can hear it.
Yes.
The letters are pretty small, so difficult to read. You read little bit louder.
I respectfully beg to state that today on 9/5/2026 at 3:10 p.m. on receipt of a reliable information, source information as well as information communicated by superior officer, it was learned that one government subsidiary tractor, which actually it is power tiller,
You read out.
which had been provided under a government subsidy scheme for local agricultural use, had been dishonestly misappropriated and illegally sold at a very cheap rate by one Tahir Ahmed Borbuya, son of Abdul Hasim Borbuya, resident of Basdor Part 3, PSN district, Hailakandi, Assam, in pollution with some other parts. It was further learned from the information received and the accused persons after obtaining the benefit of the government subsidy scheme instead of utilizing the tractor for the purpose for which the subsidy had been granted, fraudulently disposed of the same and thereby caused wrongful loss to the government exchequer as well as defeated.
We'll call for CD in this case.
And here, my lord, background is that, my lord, lordship, I have annexed, my lord, two documents, lordship, page 16, in the name of my lord Omar Burman, and another, my lord, sanction letter, page 19, my lord Rajiv Burman. They are, my lord, poor cultivator, my lord, and they approached to the petitioner, my lord, to help them to purchase the, my lord, this power tiller. And accordingly, my lord, page 22, my lord, this petitioner before your lordship, on their behalf, my lord, they paid for this to power tiller's price.
You will look into
Accordingly, my lord, by geotagging, my lord, he received, my lord. But as my lord,
Allegation is, allegation is that you have availed the facilities from the government and took the factor, and after that you have sold it in a cheap price rather than utilizing the factor. That is the allegation. So let us see what is there.
and my lord, the police themselves, my lord,
The police themselves have filed this FIR.
yes, my lord, no public, my lord.
So usually police doesn't file unnecessarily.
But actually, my lord, case is otherwise, my lord. I paid money, my
Okay, we'll
lord.
see the CD. Heard Mr. A. Borgnia, the learned counsel, A.M. Borgnia, the learned counsel, acting for the accused applicant. Also heard Mr. D.P. Goswami, learned APB for the state. He is an application under section 482 of BNSS 2023, paying for granting anticipatory bail to the accused applicant in connection with Hailakandi PS case number 68 stroke 2026 under section 61 in bracket 2 stroke 303 bracket 2 stroke 316 bracket 2 stroke 318 bracket 4 of BNS 2023. All for the CD, let the matter be listed on 24th of June.
Obliged.
Page 11 is the FIR. There are 15 persons named in the FIR. Petitioner before your lordships are accused number 6 to 10. 6 to 10.
Yes.
There was a scuffle between two groups, my lord, and the petitioner were the neighbors where the scuffle took place. They went to visit. Well, the page 12 is the FIR.
You call for the CDM, Mr.
One thing I would, in the FIR itself, they have stated the accused number 12 is the person who have made the attempt to kill Miller. In petitioner number 1 and 2, Miller, they are ladies, Miller. In outraging of modesty, Miller, attempt to kill, and attempt to kill has been stated to be done by accused number 12. I'm not pressing for the other petitioners, Miller. Only petition number 1 and 2, they are ladies, Miller. Outraging modesty of a woman, Miller, will not affect, Miller, and attempt to kill also, Miller, that was done by accused number 12, Miller. Accused numbers 9 and 10, Miller, are the petition number 1 and 2, Miller. Only praying for these two, man. Yeah, ladies, Miller.
These two ladies will give interim intent to them. Otherwise, let others come. See, it's a group. I mean, the small castle. I mean, became a little bit bigger. Okay, heard Mr. K. Muni, the learned counsel, appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APP for the state. This is an application under section 452 of VNSS 2023. Praying for granting PRS bail to the accused applicants in connection with Patachal police station case number 50/2026 registered under sections 329 bracket 4 stroke 115 bracket 2 stroke 76 stroke 109 stroke 118 bracket 2 stroke 303 bracket 2 stroke 35 bracket 5 of the BNS 2023. An FIR was lodged on 24/2026 by one Sukurzan Nesa, the informant, alleging that on 18/4/2024,
that 2024 should have been 2026. 2024, 18/4/2024.
It should be 26.
It is not wrong in the translation, Madam. It is there in the FIR itself, but in the that is why I have annexed the forwarding report. In the forwarding report, they have stated
26, no?
2026.
Yes, Goswami, it will be 26. 18/4/2026 in the morning at around 11 a.m. The accused, several accused persons, including the accused applicants in the instant case, had an altercation with the informant regarding plucking of some mangoes of her garden. Semicolon. That on 19/4/2026 at around 10 a.m. she and her husband wanted, and other family members were getting ready to visit a police station for intimating about the incident happened the other day. However, while preparing for visiting the police station, several persons came in a group, including the accused applicants, and informant and their family members have been attacked by them with sharp weapons, with sharp objects like the rod, stick, etc. That due to such attack, the petitioner and the informant, as well as her husband and other persons, got injured. So it was on a semicolon that the accused applicant was alleged that the accused applicants tried to outpraise her modesty also. On receipt of the affair, the police registered the Patasar police station case number 50/2026 under the Prohibitions sections. Mr. P.K. Muni, the learned counsel, according to the accused applicant, submits that there was a small altercation happened between the two families, and nothing serious happened, and there was no occasion of outpraising any modesty of the informant by the accused applicants in the instant case. See, he further submits that the accused applicant number 1 and 2, being ladies, they are definitely not involved in outpraising the modesty of the of the informant, outraising the modesty of the informant. Therefore, he submits that the accused applicants should be released on pre-arrest bail pre-arrest bail prospectus. Mr. D.P. Goswami, the learned AP, on the other hand, opposes the bail application, opposes the prayer for interim bail and a prayer for pre-arrest bail. Also, taking into account of next paragraph, taking into account the facts as well as the fact that accused number 1 and 2 are accused applicant number 1 and 2 are ladies. This court is of the view that accused applicant number 1 and 2 should be granted interim relief at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant number 1 and 2 in connection with Pakistan State Police Station case 950/2026, they shall be released on bail on punishing of bail bond of rupees 20,000 with a security of like nature to the satisfaction of the arresting authority, subject to the condition that the accused applicant shall appear before the investigating authority within a period of 10 days and shall fully cooperate with the investigation. Next paragraph. All for the CD. Let the matter fixed on 24th of June.
Accused number 9 and 10 are the petition number 1 and 2.
Huh?
Accused number 9 and
we have mentioned about accused applicant number 1 and 2.
accused, my lord, 1 and 2 are different, my lord.
Accused applicant number 1 and 2 in this petition.
I'm obliged. I'll deep lord.
This petition accused 1 and 2 will put the name also. Full Khatun and Ismitara Khatun. These two persons. Huh? They have been given interim bail.
I'm obliged. Deep lord.
My lord, this is my lord, regarding my lord, transit 2063 bail, my lord. Transit 2063 bail, my lord. This, my lord, a case registered in the, my lord, at Uttar Pradesh police, my lord, notice was issued, my lord.
Show me the FIR first.
My lord, there is no FIR, my lord. My lord, notice, my lord,
What
I have
notice?
my lord, that is page, my lord, 12, my lord. Annex 2, my lord. Page 12, my lord. Notice, my lord, issued under section 35(3), my lord. So, my lord, I am, my lord, directed to appear before the.
So go and appear.
My lord, yes, I will appear, my lord. In the meantime, my
Why should I give you interim protection?
my lord, because, my lord, that there is no date and time, my lord. In the notice, my lord, there is no date and time, my lord. And it is received, my lord, by the Udalguri police station, and subsequently I have been handed over, my lord. So, in the meantime, my lord, already, my lord, time has gone, my lord. My lord, similar order, my lord, I have.
Where is the date?
My lord.
Notice was issued to him, lordship, on
There is-
28/25.
Huh?
Notice was issued to him 28/25.
Page.
Page 12.
Page 12. 12 is the translated version.
Copy. And the
Main copy, what is the date? There is no date.
Here is, my lord, there is no date, my lord. There is no date, my lord. And subsequently, my lord, another 3, my lord, a letter has been issued, my lord, from the Uttar Pradesh police to the
It is some where?
my lord.
Udalguri.
Udalguri, yes, my lord. Now, thereafter, my lord, I have
No, it is done for Kushinagar.
yes, my lord. So, my lord, my lord, I have annexed a similar order, my lord. That is page, my lord, 41, my lord. Already, my lord, it is honorable to grant it, my lord, in 2020 my lord.
Notice was issued
So, my
to him
lord,
on 20/08/25, and he was instructed to appear before 29/8/25. As per the notice, lordship.
You are hereby informed the concerned police station and everyone has been registered. In connection with the state.
Survey committee 29/8.
Therefore,
so, my lord, I am ready to face my lord, appear, my lord. In the meantime, I will be, my lord,
there is no date time has been given. When to appear, when not to appear. What kind of this thing is this?
an example 5 minutes similar order, my lord. I
paid for the similar order.
Here it is written, however, for this notice, you are directed to cooperate with the investigating officer during the investigation of the aforesaid.
What is at page 14?
My lord, page 14 is my lord, notice, my lord, subsequently a notice issued, my lord, to the officer in charge of Udalguri police, my lord, within my jurisdiction, my lord. And thereafter, my lord, I got regarding the, got information regarding the people notice, my lord. And thereafter, my lord, I have obtained, my lord, bank statement and the others, my lord, and subsequently, my lord, I am ready to face the trial, my lord, I am ready to, my lord, appear before the officer.
Only for transit bail, Lord.
Yes, my lord. That is
16 days time to appear before a proper application to competent authority.
a order was, my lord, passed by the court in advance of this summer, my lord. So 30 this time may be granted, my lord. In the meeting, I will appear.
We can allow him only to go to the appropriate
Yes.
court to this thing. We cannot allow him to
No.
this. Yeah. But this order was passed. You see the order 41. So Goswami, that he has been given bail and that bail cannot be given.
No, bail cannot be given.
In that case,
Only for that period, Lord. Only for that period.
only the transit period, and you go there and approach
Yes.
approach the jurisdictional court
Yes.
for appropriate relief.
Only for that.
Yeah, we cannot allow you to go on bail.
They also have to explain the delay. The delay part also they have to explain. They have to satisfy lordship why they have.
30 this time may be given, my lord. My lord.
30 days time. Why 30 days time? You require 30 days to go there.
Yes, ma'am.
To Kushinagar.
Yes, ma'am.
Why?
My lord, in the meantime, my lord,
30 days to go there in Kushinagar.
no, my
How
lord.
many days you want?
In the meantime, my lord, I have to, my lord, prepare, my lord, a person, my lord, who is, my lord, having acquainted to the language, my lord. My lord, I am Assamese language speaking, my lord. That is why, my lord.
Heard Mr. A. Hussain, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned appearing for the state. This is in application under section 482 of BNSS, made with 528 of BNSS, paying for granting transit anticipatory bail to the accused applicant in connection with Barua Patti, PS, crime case number 99/2024, under section 308 in bracket 2, stroke 318 bracket 2 of BNS registered at Barua Patti Police Station, District, Kushinagar, Uttar Pradesh. It is the case of the accused applicant that he has received one undated notice under section 35(3) of BNSS from the investigating officer of police station Barua Patti, District, Kushinagar, in connection with Barua Patti police station, is crime number 99/2024 under sections 308 bracket 2 stroke 318 bracket 2 of BNS to appear before the concerned police station, police station, full stop. It is seen that it is seen it is contended by the petitioner that though the notice was received by him, since there is no time provided in the aforesaid notice, the petitioner could not go and appear before the aforesaid police station. Also, it is contended that later on the petitioner found out from an intimation to the officer in charge of Udalguri police station by the officer in charge of Parvapatti police station dated January dated January 2026. Dated nil January 2026. That there is some allegation against the accused applicant regarding transfer of the transfer of an amount of rupees 12 lakhs in his account maintained in Bandhan Bank. Next, the learned counsel appearing for the accused applicant submits that he is willing to appear before the concerned police station. However, since he is an illiterate person, he requires some time to go to Kushinagar and appear before the concerned police station. Accordingly, he pays for a transit bail, the privilege of transit bail, so that he can go and approach the appropriate jurisdictional court for a proper anticipatory bail. Taking into account the process, this court taking into account the process, it is directed that in the event of it is directed that 10 days time from passing of this order is allowed to the accused applicant to approach the jurisdictional to approach the appropriate court for PLS bail, if so advised. Accordingly, it is directed that in the event of his arrest by the arresting authority in connection with crime case number 9 and in connection with Barwapatti police station case number 99/2024, he shall be released on bail on punishing of bail bond of rupees 20,000 with a CLT of like nature, the satisfaction of the arresting authority. Also, it is directed that within 10 days of passing of this order, passing of this order, the accused applicant shall approach the appropriate court having jurisdiction for further relief, if so advised. In view of the opposite direction, the instant AB application is disposed of. 10 days time, you go there and file and make it 15 days. 15 days. 15 days time has been given. Go to the proper court and take anticipatory bail there.
In the meantime,
In the meantime, 15 days, you get given transit bail. But this bail will lapse after 15 days. You'll have to take bail there. This court cannot give you unlimited bail.
similar order there.
That cannot be done. That cannot be done. Anticipatory bail cannot be given, just like that by a court which doesn't have jurisdiction. It is only transit bail can be given. You can go there and approach.
Yes,
Case 15 is the FIR in Vanapilla. One.
Yes.
Miller, one FIR has been also lost from our side, Miller, page 18, Miller, but it was not registered by the police. The petitioners and the Miller informant are next door neighbors. Miller. Some altercation was took place, Miller, and ultimately it has been given a color of Miller physical torture and all. My lord, the IO was directed to make an investigation, page 16, my lord, by the officer in charge.
Yes. What happened?
Middle portion, my lord, also kindly peruse.
Page 17.
Page 16, my lord. Before registering the FIR by the informant, my lord, the IO.
So what has happened to that?
Well, kindly peruse paragraph middle portion, my lord, which respect on some humble submission. I have the honor.
Portion of 16.
Page 16, my lord.
With due respect, humble submission. I
Due
would
respect,
that,
yes, my lord. It has been said only the cognizable offense has been found to be committed.
So,
my lord, there is nothing serious, my lord. They both the informant and the petitioners are, my lord, the next door neighbors, my lord. If they are, my lord, arrested by the police, my lord, there will be, my lord, grudge and enmity will be there, my lord, for good, my lord, since there is no provision for shifting of families. Kindly protect the petitioners on the ground, my lord. Otherwise, my lord, it will be, my lord, at least for 4 or 5 days, my lord, before calling the sitting. Otherwise, social fabric will be damaged in the area. Simple case, my lord. FIR has been written by someone else, my lord, on behalf of the informant. Page 15. If there is any material loss, may dismiss the bail, interim bail. In fact, they have attacked the informants, my lord, the petitioner number 3, my lord. He was attacked by the informants. My lord. Next door neighbor, my lord.
One is to irrigation against the one.
Only against us.
That some land was,
Yes.
probably they were constructing something, the road was blocked because of their land. Mr. P.J. Sakia, the learned counsel according to the accused applicant. Accused applicants also heard Mr. P.P. Shamila updated participate. Is an application under section 482 of the NSS to be complete for content creators bill to the accused applicant. Which was proceed. Yes, this number is 226 under section 296. Stroke 131, stroke 118, bracket 1, stroke 115, bracket 2, stroke 74, stroke 3, bracket 5 of the NSP. An FIR was lost by one. An FIR was lost on 168.65 alleging that while the family members of the informants were discussing about the blockage of road by their neighbors, that is the accused applicants, the accused applicants came and without any provocation after using certain slang languages attacked them, thereby injuring the informant and his family members. On receipt of the FIR, the police registered as purported PS case number 28/2026 under the aforementioned sections. The Lord Mr. P.J. Sector, the learned counsel by accused applicants submits that the accused applicants as well as the informant are next door neighbors, and some altercation happened due to due to blockage of the road by putting earth by putting a truckload of earth there. There, which we submit that there is no such injury which has been alleged in the affair occurred to any of the persons of the informant's family. It further submits that they both are neighbors and have been peacefully residing in the locality. We submit that the custodial detention in the instant case may not be required for instant case, and that the accused applicant should be granted. So DP submit the right. On the other hand, it is the bill. They are okay. This court after considering that is of the considered view that whose applicant should be granted the privilege of clear as well. Accordingly, it is directed that in the event of arrest for the accused applicants, the accused applicants shall be released on counseling of the account of rupees 20,000 each with a severity of life nature except the satisfaction of the arrest penalty, subject to the condition that the accused applicants will appear before the investigating authority within a period of 10 days from passing of this order. The accused applicants shall cooperate with the investigation and make themselves available by the investigating officer. The accused applicant shall not try in any way influence any witness that may be involved in the extent in view of the proceed direction, the investigating application is disposed.
Evening.
May it please your lordship.
This is submitted.
Lordship, I kindly see that allegation he uploaded one video, lordship. There are some.
Go there, Mr. Ahmed.
We go there. The nature of the allegation and lordship that length of detention.
Charge sheet has been submitted now. Heard Mr. A. Ahmed, the learned counsel, appearing to the accused applicant, also heard Mr. Dupik Goswami, the applicant for the state. This is an application under section 483 of the Business System for grant of bail to the accused applicant in connection with Sunai PS case number 41/2026 registered under sections 196 in bracket 1 bracket A small stroke 299 stroke 351 bracket A stroke 352 stroke 351 bracket 1 bracket C stroke 49 stroke 62 bracket 2 of VNS. An FIR next para. An FIR bracket 12/2026 was lodged by the informant alleging that the accused applicant is spreading a provocative and abusive video on social media against the vice chairman of Sunai Municipal Board and consent president of Baksandi Development Block. Full stop. The learned APP, Mr. B. Sharma, Mr. DP Goswami, the learned APP submits that charge sheet in the instant case has already been filed by charge sheet number.
Yes, number 40/26 dated 7/6/26.
2026. Full stop. In view of the aforesaid, in view of the aforesaid, the learned counsel, in view of the aforesaid, the instant bail application is the bail application is closed with the direction to the accused applicant to approach the appropriate court for any relief if so applies. Come back.
This is a regular bail application, Lordship. Matter pertains to recovery of commercial quantity, Lordship. Lordship, may first comes to the fact of the case, Lordship. FIR is on page 25, Lordship. Lordship, here recovery was made from one co-accused, namely Biswajit Saha, Lordship, from a warehouse of Minal Burman, Lordship. The recovery was regarding 3,000 bottles of cough syrup, Lordship. In
10 big cartoons and each cartoon containing 12 small cartoon packed by yellow sticker. Lordship, thereafter, Lordship, the petitioner has been arrested, Lordship, and upon the statement of the co-accused, that is Biswajit Saha, Lordship, and until today, Lordship, it is 308 days, Lordship, behind the bar, Lordship. And charges are framed under section 22C, Lordship, against all three accused. Two accused are behind the bar along with the petitioner. One accused has been granted bail by your Lordship. And Lordship, apart from the co-accused statement, Lordship, the following grounds of arrest are given to the present petitioner, Lordship, which is on page 53, Lordship. 47 notice. Upon this grounds of arrest, Lordship, the present petitioner was.
Who was granted bail? Who was granted bail?
Sorry, Lordship.
Who was granted bail?
Lordship, Anup Pandit, Lordship.
Where is the order?
Wide order dated, Lordship. I could not procure the Lordship the bail order, Lordship. I will give the bail application number, Lordship.
Why the order is not given? Given that would have been beneficial to.
Anup Pandit, Lordship, his ground was separate, Lordship. My ground is different, Lordship. He was granted bail on the ground that there was violation on 36 notice, Lordship. My ground is totally separate, Lordship. Lordship, the 47 notice, which is in page 53, my grounds, Lordship, on the ground of arrest, which was given to me that I was involved in the loading of those cartoons in that godam, Lordship. Thereupon, Lordship, after search sheet, Lordship, 6 witnesses are there on 6 witness has been there are 6 witness total, Lordship. Search sheet is on page 39, Lordship. Lordship, bail application of co-accused was bail application number 3265/25, Lordship.
Okay. 6 witnesses, how many examined now?
Lordship, witnesses are not examined, Lordship. Not a single witness has been examined. Charges are framed. It is in the stage of evidence, Lordship. And Lordship, the 2 witnesses are independent witness, Minal Das and one Santosh Singh. Charge sheet is on page 39, Lordship. Minal Das, as per the charge sheet, he is the owner of the godam where the contraband was seized as per the FIR, Lordship. Lordship, but not a single witness, if Lordship goes to the LCR, Lordship, not a single witness has corroborated with the statement of the co-accused Biswajit Saha, Lordship. Apart from the statement of the co-accused, not a single witness has corroborated. There is no material on record with which the co-accused statement can be linked, Lordship. Neither there is a single whisper from all 6 witnesses apart from the co-accused statement, Lordship, which is inadmissible at this stage, Lordship. And no investigation has been made out in the part of petitioner to justify his arrest, Lordship. Lordship, I have flag marked, Lordship, the statement of the witnesses, Lordship. Be at the last. And separate copies there, Lordship.
Your bail is already rejected by the lower court.
Lordship, my bail is not been
Recently,
rejected.
when it was rejected.
Lordship, it was not rejected. It was been withdrawn, Lordship, last time.
No, that to High Court.
Yes.
In the.
But I have not
special court-
approached the lower court.
Special court, you have not.
Approached because, Lordship, until now, the prosecution has not been appointed in the special court NDPS, Lordship. And because of which we cannot do hearing in lower court.
Where is that FIR?
In my petition, Lordship, FIR, Lordship will find on page 25, Lordship. There is nothing in the FIR also against the present petitioner, Lordship. Page number 25. Lordship.
Forwarding.
Forwarding, Lordship, forwarding allegation is there. The, the grounds of arrest are there.
but mostly the FIR part has been copied and then the ground of arrest of two accused who are been forwarded by the forwarding dated 7/8/2025, which is on page 32, Lordship. As per the co-accused statement, Lordship, the contraband came from Banaras by the Airways shipment company. Then it was being loaded. Then the police intercepted on the godown. But the godown owner, which has been stated in the search sheet on page 39 as godown owner, Lordship, but in his statement, he has stated that he has subletted the godown, Lordship. Otherwise, also there is nothing, no material with which the co-accused statement can be linked, Lordship. I'm relying on Tufan Singh's judgment, Lordship. To Supreme Court observation, Lordship, in Surinder Kumar Khanna and Tufan Singh, Lordship.
You have been arrested from where? You have been arrested from the spot itself.
I have not been arrested on the spot, Lordship.
Where, from where you can say? How you can say?
Otherwise, my ground of arrest is not, Lordship, basic facts are not there.
Let me answer
But
this. You are saying that like you were, I mean, you have been implicated on
Yes.
because of a co-accused statement,
yes,
but you have been arrested from the spot.
I have not been arrested from the spot.
Then where? Then where from your side?
Lordship may come to the FIR for that, Lordship. FIR
FIR doesn't say so.
upon the co-accused statement. Lordship, in the ground of arrest, Lordship may see,
I
Lordship.
think it comes that like you have been arrested from the
His
spot.
Lordship, one para in the ground of arrest in the forwarding page 33, his absconding conduct obstruct the investigation.
He was arrested
That's
subsequently. Lord.
Yes, subsequently he was
He
arrested.
was arrested on 7/8 and the affair was closed on 5/8.
From where are you saying so?
Sorry, Lordship.
From where are you saying so?
His date of arrest is noted that according report 7/8
780 is the forwarding.
Yes.
and noted that we was conducted that investigation was conducted on Lordship 5 Lordship.
5.
There was 5.
On 6/8, then a complaint was lodged.
On 5/8, Lordship.
On 5/8, entry was made.
On 5th of August, Lordship, 2025, where Lordship Biswajit Saha was arrested. If Lordship comes to the Biswajit Saha statement, Lordship, it will be clear, Lordship. Co-accused statement, Lordship. And in the ground of arrest also, Lordship, they have stated that I have been absconding, Lordship. Later on, I have been arrested.
On that day, he paid away Lordship, but Lordship, when he was loading those contraband in that vehicle Lordship, the vehicle driver was Biswajit Saha. And on coming, when he saw that police is coming towards his godown, he immediately fled away. That is the
It is a statement.
that is the it depends from the statement of Biswajit Saha.
Biswajit Saha.
So Lordship, one person, if he do not know what is there in the cartoons and he fled away, it indicates that he knew that what he is doing and what is there in the cartoons, Lordship. Because police may for other purpose, Lordship. Immediately on seeing that Lordship, police is coming, he fled away.
Even if that part comes, Lordship, as earlier I have stated, Lordship,
there is no witness to corroborate with the statement of the co-accused. Even if that part comes, there is no one in the entire list of witness whom we can put a question that whether Biswajit Saha, according to the prosecution, whether he was consciously aware or he has mental state or not. That question cannot be put to anyone, as the Godam owner has also stated that he has subletted the Godam, Lordship. And no one has been interrogated, Lordship, regarding the allegation part of the co-accused, Lordship.
This is very Lordship, this is not a meaning trial, Lordship. So Lordship, for that all corroboration that will come in the trial, Lordship. But primarily whether his involvement is there or not, Lordship, that has to be looked into. That may be looking.
Lordship, the Supreme Court observation which I have submitted, Lordship, that Tufan Singh's judgment was also taken into consideration at the stage of bail, Lordship. May I read one paragraph from the Tufan Singh?
Yes.
Lordship, may I read the para from Tufan Singh's judgment, Lordship? Tufan Singh, Lordship.
This is placed by whom?
Lordship. This is not, I have submitted, Lordship.
Which
in-
paragraph?
Lordship, paragraph number 8, Lordship. What I'm submitting, Lordship, that in paragraph number 8, Lordship, in cases of nature, the respondent may be able to take advantage of the decision of Tufan Singh versus State of Tamil Nadu, perhaps at the time of arguing the regular bail application or at the time of final hearing after conclusion of trial. And what Tufan Singh says that, Lordship, the only co-accused statement, Lordship, apart from which, if there is no link, Lordship, confessional statement, Lordship, may read the relevant para on page 130, Lordship. Page 130 from the Tufan Singh judgment. 130 page. Page 130, Lordship. Page 130. Paragraph number 153, which is bolded in the judgment itself. Lordship has found, Lordship. Lordship, needless to mention that having regard to all.
Para 153.
Para 153, I'm just reading out the relevant part, Lordship.
No, whether you read from
Whether-
from where you are reading, how will you know? How will I know?
Sorry, Lordship. 153, Lordship, whether the officer concerned is duly empowered and or authorized to make an inquiry, investigation, whether any statement or document has improperly been procured, etc., are factor which would have to be examined by the court on a case-to-case basis. Needless to mention that having regard to all relevant facts and circumstances, the court may not base conviction solely on a statement made in an inquiry which is confessional. In the absence of other material with which the statement can be linked, it is for the special court to weigh the statement and assess its evidentiary value. Having regard to all relevant factor, all statement and document tendered in evidence have to be proved at the trial in accordance with law. And recently, Lordship, the Indira Banerjee's the judgment which I have submitted, the Tufan Singh can come to rescue while arguing the regular bail also. Lordship, this is my submission, Lordship. With regards to the all 6 witnesses which are listed as a witness,
Yes.
no one has whispered my name, Lordship, apart from the co-accused
Yeah,
statement.
it is also in the said paragraph.
Who are the witnesses? Who are the witnesses?
Sorry, Lordship.
Who are the witnesses? Which witnesses did not take your name?
Lordship,
I-
all 6
if you find people taking your name.
all 6 witnesses, Lordship. PW1 Rahul Das, Lordship.
Once.
On page 39 is the charge sheet, Lordship. UBC Rahul Das, Lordship. LNK, Lance Naik, Karuna Kolita, Mrinal Das, and Santosh are independent witness. Whereas Pranab Jyoti Bhattacharya is the seizing officer and the Rinkumoni Bora is the IO, Lordship. May I read one more para from Surinder Kumar Khanna to clarify?
No, no, that I you have gone through this.
Also, I have confirmed. That I have confirmed also. I have taken that statement of the driver authority. It's so class. And another person of the Oru experience.
I have taken one more plea, Lordship. Regarding 47 notice.
Surinder Khanna, which?
Yes, Lordship, para number 14, Lordship. Last page, Lord. Page number 7, Lord. May I read, Lord? In the present case, it is accepted that apart from the aforesaid statement of co-accused, there is no material suggesting involvement of the appellant in the crime in question. We are thus left with only one piece of material, that is the confessional statement of the co-accused, as stated above. On the touchstone of law laid down by this court, such a confessional statement of the co-accused cannot by itself be taken as a substantive piece of evidence against another co-accused and can at best be used or utilized in order to lead assurance to the court. In the absence of any substantive evidence, it would be inappropriate to base the conviction of the appellant purely on the statement of co-accused. The appellant is therefore entitled to be acquitted. This is what I am submitting.
Regarding conviction and acquittal Lordship. This is not regarding also at this
This is similar to Tufan Singh, Lordship, and Supreme Court has recently made the observation in Indira Banerjee case, Lordship, that it can be benefit may be used in the regular bail also. If I am not wrong, Lordship, there is no chance of conviction for the petitioner in this case. Huh?
My humble submission is that Lordship, here in this case also he is fully involved Lordship because he knew that what is the article in the cartoons, and on seeing the police person came, he immediately fled away. So Lordship, he knew the consequences Lordship. That thereafter Lordship, one more witness is accused person. That person he has also implicated him. That same. So Lordship, two witnesses, two co-accused has implicated him Lordship.
But law is something else, no?
Lordship.
Law is something else.
Regarding Lordship.
Law in Tufan Singh is clear, right?
But Lordship, regarding for the purpose of investigation, but it is for the purpose of investigation. Lordship.
What Tufan Singh says.
He has just read out that paragraph. Lordship. It is also Lordship for the not based on conviction. Lordship.
What Surinder Kumar and that other case that Indira Shah says.
Surinder Kumar has said Lordship regarding that.
What Indira Shah says.
Indira Shah, that I have not read the Lordship. That Surinder Kumar Lordship.
See, forget about conviction in the case of bail also. That is a very important aspect that has to be taken into consideration by court. This is settled law, and you being an APP before this court for so many months or years, I do not know. You should be aware of this.
But Lordship,
whatever the settled law, you should point out to the court.
Settled law, Lordship,
you should not argue on certain things which is not settled. Which is the settled law, you should argue, Mr. Locker. So this is a settled law. Tufan Singh has been followed in many cases. Only on the basis of co-accused statement you cannot. And that is a very important aspect that needs to be considered while granting or rejecting a bail. That Supreme Court has said in many cases. Then how will you argue that?
But regarding that paragraph, he has just read out.
You show me some material from the records that independent of the co-accused statement, there are certain other materials also he's involved. Then immediately his right of bail will go. But instead of doing that, I mean, if you argue on that to Tufan Singh's line, to a case's line, then it will not help. Because it's a settled law. It has been stated that you just go through it. I'll give you some time, you go through it, let him go through it. I'll give you some time. But as far as that Tufan law case is concerned, Supreme Court has settled it. that is a relevant material to be considered during consideration of the bail. Conviction, that is already there. These are the punching and other cases on conviction. But Supreme Court stated that that is a relevant aspect that needs to be considered while considering a bail. So if there are certain, if independent, any other independent material, then that helps your case. You go through it. You take it up. Go through it properly, Mr. Locker.
May I please answer?
Regular bail application, my lord. The petitioner is behind bar for 23 days. FIR page 17.
Mr. Locker, you take this case also. You just go through it. Yes.
Page number 17 is the FIR.
I have made a prayer for another date. He has not, he cannot produce the case date today.
Lord, sir, in fact, in this case, 35 notice not charged, my lord. And in the page number 34, this is the order of the learned court below. There is specifically recorded the statement of IO, my lord, page number 35. And para number third paragraph. Page number 35. Third paragraph, may I read, my lord? The IO, on being asked, stated that notice under section 35 BNSS could not be served upon the accused person, as the accused person absconded when he was contacted over phone by the police, and later on he was apprehended from Dibrugarh. It cannot be a ground for not serving 35
We
notice.
will wait for the CD. Let us see what is there in the CD, then we'll decide.
There's a short date may be given, my lord.
Yes. Comments?
P. Bora.
He brought a learned counsel.
Next question.
We have to be for the state. Next CD is yet to be received. Let them release it on 23rd of June.
Yes.
23rd of June. Next week.
Next week, my lord.
23rd of June.
Last week.
Or we'll put it on 17th of June. 17th of
23rd is.
17th of.
Yes.
Mr. Papagar. 18. 18.
The precon, my lord. 16th.
18. 18.
Obviously.
Mr. We have received the case diary, Lordship, but PM report is not available in the case diary. It's a case of 106 to 103, Lordship. CDM not say. More used to the more used to. अपना AB PM also debit. PM report
My lord, mine one is an AB, my lord. CD has come, my lord. But my learned friend is submitting that PM is not there. But my story is like that, my lord. The deceased was my friend, man. On 21 February 26, my lord. Deceased asked me to help him to some money, my lord, which I declined because my friend is an alcoholic one. I thought that he will expand the money. Then, my lord, he and another friend, Saurabh Dutt, they had a drink, my lord. Then, my lord, thereafter, my lord, in the evening, when I was telephoning a call that he has become very already taken overdose, my lord. So we should send him to his house. Please come. Then I took him to in a scooty, my lord, and left his house where one of our friend is there. But in the night, my lord, his condition was deteriorated. He was hospitalized at the Apollo Hospital, Gauhati, where he died. My lord, initially there was no affair, but police called me several times in the police station. Then because I taken him to his house, then, my lord, I approached the Honorable Court, my lord, for a clearance bail without affair. Honorable Court granted it.
and called for the CD. At that time, no case was also even registered. Then ultimately case was registered. I have already submitted another affidavit before the Honorable Court with the new case number that case has been registered. Then one of the person has been, in whose house he had a drink, he was taken into custody. And I think for that, my friend, another friend is moving their bail for under 439. Now, my lord, for me, my lord, PD has been called for. Probably nothing is declared against me, my lord. I have given my statement before the IO.
Interim lordship, wait for the PM report after looking. He's an interim lordship. He's an interim. He has statement, they have not found it there also, whether he has appeared or not.
I have appeared even before this registration of the case also. My statement was recorded now. After registration also I appeared. Yeah. And this is mobile phone has been already seized by the police. Aryan Ketchup Kakoti.
This statement is only the case dry lordship, so wait for this statement lordship and is an interim lordship and the PM report is required in this case.
Yes, PM report definitely. For how he died.
Some other date then.
Lordship.
CBA policy that we will be published. On when was
23rd?
No, sir. 23rd, I cannot manage. There is the Ambavuchi, I will be busy.
When do
Before that, manage it possible.
19.
Interim shall continue for me.
Interim what is so fast.
I am for the item number
Other
30.
cases also.
Okay. He's behind the bus.
Lordship, I am behind the last 16 days.
Item number
30, Lordship.
30. Item number 30, right? And put it in the same date.
Development.
CP not put the PM, same model. No.
31 lordship, this was an interim. We have not received the case diary.
Is there not received? Interim model so fast that it's either method to the state or 24th.
23rd of
23rd of
charge sheet submitted.
obviously create one lot of concept. Also have to speed. Two copies speed. Paying for that we are speed. Under CP 96 stroke 115 stroke 1 stroke 3 PM speed. Well, only
White charge sheet number 45/26 dated 14/5/26.
can be a purpose. This can be closed with the direction. With the direction. Within a period of 10 days. Within a period of 10 days. From this order, it price. Till his appearance before. The intent surpassed by 4.6 centimeters. In terms of the direction, and some of the.
Yes, city was called for that. Minor FR page 8 locking. FR page 8 locking.
Yes, Mr. That's.
Yes, Lordship, what I have seen, Lordship. In the FIR, it is clearly stated that Lordship, he has made physical relation because he induces to marry him, marry her, Lordship. And section 69 also clearly stated that whoever by deceitful means or by making promise to marry a woman. And in her 186, Lordship 180 statement, she has created the same thing.
She has been having this relationship for a long time. That
But on the-
incident happened 6 months back.
But the thing is that-
She's a major lady.
But one thing is there, Lordship. She stated that he made a promise to marry her, and in the subsequent days, Lordship, why she has filed the FIR? Because he married to another person.
Out of life, my lord.
Because he married to another girl, Lordship, and she is pregnant. It is because of that she has not filed FIR before, because she is in belief that he will marry.
No, my lord, that is.
He will marry, but after she came to know,
Incident-
she became married to another girl, Lordship. And she is 25 weeks pregnant. Then Lordship, this is a deception from the initial
No,
inception,
my lord.
Lordship. Because he has no intention to marry.
But-
Why then he has
Yes,
married to another girl?
I'll
Let him submit. Huh?
Then why he has married another girl? Lordship? It is because of that he has not filed the FIR. Because he is in the belief that he will marry.
Let me see the statement.
Lordship. The last two lines.
Yes, she sits on that. She has a law paper for long day, for long many years. my lord.
You have been cheating at.
Lordship.
Mr.
Yes, Rahman.
As Rahman, the learned counsel, to the accused of the counsel, so people, so take it as per of speak. Is an application for for paying for the claim that with India, yes, case number 34/6 under section 69. Of claims. And I thought it was asked for. By 2/6 by the informant alleging that which was who was in the informant was physically expelled but were on the promise of marriage back, 6 months back, from 6 months back, from highly popular that if I refuse person, refuse person who got the nearest school, nearing also, he have physical physical with people that so 6 months, and 6 months, like, in your person. The India is six. In the automates, rejected.
Lordship, this is a 482 application. The CD was called for the FIR is at page 16, Lordship. The FIR is at page 16. May I read the FIR?
Please.
16, Lordship. 1-6. Shall I read the FIR, Lordship?
Yes.
মহোদয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 2-5-2026 3-5-2026 তাৰিখৰ ৰাতি 4-5টা অজ্ঞাত লোকে মোক গোহালিৰ পৰা ওপৰত উল্লেখ কৰা দমৰাটো লৈ যায় চুৰি কৰা ঘটনা মোৰ ভাড়াত দিয়া দোকানৰ CCTV সম্পূৰ্ণৰূপে আছে 3-5-2026 তাৰিখৰ পুৱতি নিশা 3 বজাৰ পৰা 4ৰ ভিতৰত চুৰি কাৰ্য সংগঠিত হৈছিল গতিকে দয়ালু মহোদয় দয়া কৰি বিষয়টো বিচাৰ কৰিবলৈ অনুৰোধ কৰা হ'ল Now, Lordship, the principal accused persons have already been identified through the CCTV footage and they have been arrested. The present petitioner is apprehending arrest only on the basis of the statement made by a co-accused.
Yes.
Yes, Lordship. What I want to state here, Lordship. In the CCTV footage, Lordship, these 3 persons, this is the Qasim, Ibrahim Ali, and Vijay Talibdar. I have seen that they have stolen the cattle, Lordship. Then they have stated that they have told this, the cow to these 2 persons, Lordship. One is Khan and another is the present petitioner. 17,000 has been taken from them. It is the space, Lordship. And they had sold it to cut it and sold it. Lordship.
Your name?
Miss P. Lordship.
Releasing by the informant releasing that some persons have stolen but from his said from his said between the night of 5-6 was 305 6. And I was confused. The learned counsel refused applicant to be valid appeal in arrest because his name was not taken by the arrest accused party. Is that in bank sentences with refused for this court to series 7% after finding from person sufficient to this court is not required to grant rejected.
So receive the case. Please, Lordship. This is clearest bail application, Lordship. Kindly see the page number 8, Lord, which is FIR page. May I read the FIR, Lordship? With due respect that on 11/4/2026 at about 6 a.m., my daughter, namely Sabina Begum, 16 years 4 months, missing from home. After that, I came to know that one boy from our village, namely Jaherul Islam Sohanshu, had eloped my daughter with the intention of marrying her. On 12/4/2026, after pressure was exerted upon the accused family by me, then my daughter was handed over to police station on 21/4/2026 at about 6. They keep my daughter secretly for many days. Accused was assisted by many persons. Lordship, this is the FIR, and actual fact of the case is that, Lordship, victim and the accused person were stop, Lordship. Date of birth is 2009. Actually, it's a minor one.
What's your name?
ये होता
All this view that I will talk about these sort of
(22/4).
On
22/4/2026.
22. (23/4).
22.
22/4/26. Saha Alam. That one boy from your village. Jaherul Islam. Taking away his daughter. We use the type of this which under under the it is very landscape which has been the region of the place by repeating found the submission made by the council of the further supported of the people that the accused applicant should be granted clearance according is valid in the event of arrest of the people by the arrangement for the recently released from the parties of the bond of the people with a single of likeness of the dismissal of the arresting of the subject that the accused applicants have the investigating officer within 10 days of passing of this order. But the accused applicant keep cooperate with the investigation and make things to be very good as in all for the or and the accused applicant can try to get in touch with the victim girl and shall not try to influence any evidence that may be involved in terms of the person Mr. Goswami, nothing is there. And the girl is recovered. Already. There is no allegation of any sexual assault.
I beg your
I
lordship
don't-
indulgence.
Yes.
Lordship, I'm extremely sorry. Item number 24, bail hearing. Actually, Lordship, I asked my junior to fix the matter at 2, but unfortunately, he took some time. So Lordship has fixed the matter on 16th. So kindly accommodate Lordship today at any time, Lordship.
Okay, it will be difficult.
Because Lordship, he's a psychiatric patient in custody for last 34 days. Lordship.
16, we have given it not much.
Kindly, if possible, Lordship. I'll be obliged, Lordship.
Okay, we'll see. We'll see.
Lordship. I'm obliged, Lordship. I'm obliged. At any time during the day, Lordship.
We'll see.
Lord.
Wherein relying the discussing the to function judgment or the bail has been earlier in a high court by the high court. It was bail was granted. That bail order was retained. Okay.
Now, which paragraph?
Paragraph 16 of it.
Paragraph
16. Paragraph 16. Coming back to the facts that facts of the instant case, the learned single judge of the High Court cannot be faulted for holding that the appellant NCB could not have relied on the confessional statements of the respondent and the other co-accused recorded under Section 67 of the NDPS Act in the light of law laid down by the three judges bench of this court in Tufan Singh Chupra, wherein as per the majority decision, a confessional statement recorded under Section 57 of the NDPS Act has been laid to be inadmissible in the trial of an offence under NDPS Act. Therefore, the admission made by the respondent while in custody to the effect that he had illegally traded in narcotic drugs will have to be kept aside. However, this was not the only material that the appellant NCB had relied on to oppose the kept bail application filed by the respondent. The appellant NCB had specifically stated that it was the disclosure made by the respondent that had led the NCB team to arrive at the godown of the co-accused Pramod Jaipuria, which resulted in the recovery of large amount of different psychotropic substances in the form of tablets, injections, and syrups. Counsels for the appellant NCB Hale had also pointed out that it was the respondent who had disclosed the address and locations of the co-accused, Pramod Jupuria, who was arrested later on, and the CDR details of the mobile phones of all co-accused, including the respondent hearing, showed that they were in touch with each other.
So there are
There are some other materials.
other materials.
There are some other materials, but Lordship, it is not that they, as he is submitting, that that co-accused statement is not applicable for the purpose of bail. Cannot be only on the basis of co-accused. That is not like that. Because if supporting documents we have, I admit that in this case there is no such supporting documents or supporting it. But what he is saying at that time that
He's saying that independently that is not admissible. He's saying so. And in this case, the case you have referred to, there are, in addition to that, the basis of the investigation was his statement. He stated that this narcotic substances are there, and he has led them to that place.
In this case.
In this case that you are referring.
Subsequently CDR also comes.
CDR also there are.
In my case also that CDRs they could also collect the CDR, but that has not been collected.
No, nothing is there.
Nothing is there also.
But independent materials are not there.
That is different. That I leave to Lordship, but also regarding what he has submitted, that is why I have regarded this document, that he has submitted also to funding, as far as to funding, co-accused statement is not admission.
No, that is what the law is. Co-accused statement.
If there is supportive documents,
if there are certain independent materials, there is no issue. But only on the basis of the co-accused statement, problem is that.
But he is relying on another sentencing judgment. That is also for the purpose of conviction, and to continue also conviction for the purpose of conviction, but subsequently some judgments say.
They said that has to be considered. There are many judgments.
Yes, Lordship, and Honorable Guwahati High Court 14th bench has also considered Indira Banerjee case law. I'm submitting that.
This court has also passed an order in 17/11/2025, long time, holding this Tufan Singh, the Narcotics Bureau, Pallubid Ahmed's case. I think Mr. Nawaz was there in the case. You were there in the case.
Krishna Mohan Reddy was led up.
Yeah. Then Bharat Chaudhary was relied on. All these cases, they say that it can be considered.
37 embargo is also there. So in that case, the reasonable grounds that has also been discussed in para 14.
What was there in this case?
Lordship, AB 1039, Lordship.
Huh?
That one, Lordship.
1039?
Yes, Lordship, SCC number is there, Lordship. The Indira Banerjee was relied, Lordship, while granting the relief.
No, it was objected to the bail application. On the basis of the judgment passed by Honorable Supreme Court that was delivered on 2022 SSC online 2087, Mr. Bhattakur has objected to this bail application. Now, why are you relying this?
2087 is Lordship. Then it would be my bad, Lordship. It would be my bad, Lordship. It would be my bad, Lordship. I thought that 2087 is.
Don't give cases which is not relevant at all.
No.
There is no mention of Tupansin here.
Not
Nothing has been stated. In fact, like this, it was not on the basis of that.
2087 is probably Indira Banerjee, Lordship.
Probably. If you submit a case, you submit with a big proper conviction that this is in support of your case. But probably. You come to the court and like submit something, you said it probably it is reliable.
Sorry, Lord.
One more humble submission is that Lordship, yes, there is no any violation of the any constitutional rights, Lordship. Lordship, section 37 embargo will also come.
I have other grounds also where 47 violation I have taken plea to my petition.
Right, hard to certainly maybe preparing for the case applicant. Also hard is in PS law particular land of being assessed to be free. Paying for the granting bail to the applicant in connection with NDPS case number 11/2006 arising out of lawsuit case number 235 under section 24 in the fixing of NDPS Act. What was lost by the SI in the T, namely product of the station. Which losing the receipt of certain secret property. The police team pursued Moragaon area and intercept one auto rickshaw bearing registered for PS 01HC 8330 in the deposit of one Minal Government near some state warehouse property in pursuit for the and the pursuit police station on suspicion of illegal export of certificates. Syndicate that after search of the opposite auto rickshaw that then big auto wrapped in yellow plastic sacks, each containing 12 small carton and each small carton containing 25 bottles of 100 ml extra 14 phosphate syrup for a totaling 3,000 bottles were recovered. During the search, the police apprehended for Biswajit Saha. Next year, after investigation, on the basis of statements of the opposite Biswajit Saha, the police subsequently arrested one Biswajit was in the and another person named MP Pandit. After the arrest, both the accused, all of them are in suicide jail.
No, Lachuk, one Anup Pandit has been
Right,
bail application.
After,
Bail application number 3265.
after their arrest, the opposite Anup Pandit was released for bail by released on bail. However, the accused applicant is since applicant is behind the bars since 308 days. The police has filed charge sheet in the instant case and charges have already been framed. However, no witnesses have been examined till the The learned counsel appearing in Sabi, making the learned counsel appearing to the accused applicant submits that the police has arrested the accused is first only on the basis of suspicion and on the basis of professional statement that has been made under section 67 of the NDPS Act by the co-accused namely Biswajit Saha and
Anup Pandit.
Biswajit Saha and proceed. What is his name?
Anup Pandit.
Opposite Anup Pandit. He submits that no narcotics contraband was in fact recovered by accused applicant. An accused applicant was not present at the time when the seizure was made by the investigating authorities. He submits that only due to the statement that has been made by the main accused, that is Biswajit Saha, the accused applicant has been arrested by the police. He submits that the accused applicant is falsely implicated by the co-accused in his statement reported under section 67 of the Indictment Act, which is not admissible in evidence in a trial of offense under the Indictment Act 1925. Therefore, he submits that only on the basis of the statement of the co-accused in section 67 of the NDPS Act and this PS Act, the accused applicant could not have been arrested by the investigating authorities. In support of this submission, the learned counsel has referred the referred to the following cases. Number one, the counsel versus State of Tamil Nadu, reported in 2021 SSC part. Surinder Kumar versus Intelligence Officer Intelligence Officer Directorate of Revenue Intelligence. You don't have any citation of this case. That much of homework you can't do. You come to you come to the court to do some NDPS cases, and that much of small homework you cannot do.
I've only found this.
You get money, no? Spend some money for these things also.
I've only got this order from.
You could have easily found out in SSC online or those reliable things. This is from where?
I tried to.
This is from where?
This from online lot.
Online what?
Internet
Which
lot.
journal?
Internet lot. No.
Which journal?
No journal.
Then can you place this kind of things before the court? You online you get some printout and like you place it before the court. Can you do that? Can't you find out in SSC online or in AIR or in other journals? Right. In bracket you write criminal appeal number 949 of 2018. In bracket again you write. This is not complete also. It's all cut. We don't know the proper number also. Criminal appeal number 949 of 2018. Decided on 31st July 2014. Then you write 3. Indira Banerjee. Yeah, State of Haryana versus Samarth Kumar. Reported in 2022 0 Supreme in bracket SCT 156. The learned counsel submits the review of the cheers principles laid down by the Honorable Supreme Court. The arrest of the accused applicant in the instant case is not sustainable under the law, as the arrest has been made only the basis of a statement made by the co-accused implicating him in the offense. So, PS of the learned submits that the case involves huge recovery of huge quantity of commercial and huge quantity of commercial quantity of narcotics and charges have already been against case pending evidence. Therefore, at this case, the bail should not be granted. The father submits that since the quantity recovered is of commercial quantity, the embargo of section 37 of the NDPS Act is applicable instant case and instant case. To further submit that case diary clearly reveals involvement of the accused applicant in the instant case as it is found out that when that after getting information about arrival of police, the accused applicant had fled the place of occurrence. In view of the proceedings, he opposes the prayer of bail to the accused. This court has gone the case that it produced for this court as well as heard submissions made by the counsel appealing for the respective parties. It is seen from the record that the investigation has already been completed and charges have been framed against the accused applicants. However, in response to the submission that the submission that the arrest of the accused applicant is not sustainable under the law, and the arrest has been made only on the basis of the statement of the co-accused in Section 67 of the NDPS Act. NDPS Act, this court has gone the records minutely and could not lay hand on any material which is independent of the statement of the co-accused pointing fingers to the involvement of the accused applicant in the instant case. In view of the judgments that have been relied on by the learned counsel against the accused applicant, it is settled law, that a confessional statement recorded under Section 67 of NDPS Act 1955 will remain inadmissible during the trial of the offense under NDPS Act 1955. In view of the opposite, it appears that there is no independent present and admissible evidence against the president against the accused applicant on record at this stage as of now to justify his detention and to impose the embargo of Section 37 of the NDPS Act 1985 against him. In view of the opposite factual position, factual metrics, and factual position of law, and on perusal of the materials brought before this court is to consider that in absence of any admissible evidence independent of the statements made under Section 67 of NDPS Act in record against the accused applicant, the arrest of the accused applicant in the instant case cannot be said to be illegal, and therefore same is not sustainable under the law, which entitles the accused applicant to be released from. Next, accordingly, this court is of the consider the opinion that the accused applicant should be allowed to go on bail on punishing of bail bond of ₹1 lakh with one security of like amount the satisfaction of the learned special judge Amrut Metro, subject to the following conditions: that the accused applicant shall cooperate in the trial of the case pending for the special judge Amrut Metro. That next, the accused applicant shall appear before the trial court as and when required by the trial court The accused applicant shall not directly or indirectly make any investment, make or promise to any person, who may be acquainted with the facts of the case, so as to dissuade such person from disposing of suspects, before the trial court in the trial pending against the accused applicant. The accused applicant shall not leave the jurisdiction of the learned special judge of the trial court without permission of the trial court, and when such leave is granted by the trial court, the accused applicant shall submit the judges and contact details to the trial court.
Deeply obliged.
In view of the aforesaid direction, the instantly disposed of as well.
Deeply obliged.
Repeat the case diary.
May please oblige. It is anticipatory bail application. Allegation is not abatement of suicide. Abatement of suicide, my lord. I'll just take your lordship to 2 pages. One, my lord, will find the FIR, which is at page 10, my lord. Relevant portion, your lordship will find in the next page, my lord. Yes, you should kindly come to page 5, madam. Page 5 of the petition, madam. Para 8, madam. Para 8, madam. This is our case, madam.
Yes, Mr. Goswami, what is that?
Yes, but a 16-year minor girl had come to suicide because of this, with the petition of promising first minutes and attempted to marry.
What are these people?
Yes, but he had provided a phone also, the telephone also, to contact her. That phone was recovered and seized from by the police and the sample us and to FSL. As for the postmortem report, postmortem report is awaiting for the postmortem report. It is stated that yes, he had some relationship with that this dialogue.
Their contention, my lord, is that we had initiated the relationship with the victim. Our contention is that the relationship was initiated by her. Your lordship will examine only this aspect, whether our conduct, there was any proximity of cause between our conduct, my lord, and the death of the victim, whether there was any overt instigation on our part that led to the death of the victim.
Because he didn't marry her. Refused to marry her.
Well, if a person refuses to marry, in many cases, my lord.
In many cases, marry, but mental condition of different people
My
has
lord,
different kind of this.
My lord. But my lord, if a person refuses to marry another person, my lord, that itself, my lord, the
But
person is
he exploited her. You had sexual
So
relations.
that part we are specifically denying, my lord. Perhaps the lordship will examine whether there is any material.
That part only can this girl say about that part, lordship. Otherwise,
The phone was recovered, that part will also be assigned to the FSL report from the
Now what is
phone call. The petitioner was making an arrangement to marry another girl. That after that comes the step. That is the part.
There are sufficient materials against me.
Lordship will only hear me on 2 points, madam. The Lordship may reject it, but on 2 points, the Lordship may kindly hear me.
Huh?
Lordship may reject it, but on 2 points, if the Lordship will kindly hear me, madam.
No, there is no point here.
But because as far as the sexual act part is concerned, madam.
No, there are sufficient allegations, materials against. The phone has been recovered from the head of this headmaster. Headmaster has stated that phone has been used, given by you to the other, that the girl. That what more evidence you want? At least your involvement is not, your involvement is already there. Now the only thing is that, like, I mean, sexual, this thing that can be done only at this stage. I cannot get done to. But Mr. S. Navas, the Leonard Fox, also not Mr. to submit for the state. Is an application of such. What we are paying for, at least praying for at least the applicant in connection with mobile PSP's number 239/3226. This is 108 of BNS review. And a fire was lost on 28/6 by one Muhammad Mahitu Islam. Elise that alleging that the accused applicant used the teacher of the school wherein his minor daughter used to study had developed a relation or a love relationship with her on the promise that he would be marrying his daughter. That's a that with such also promise, the accused applicant has developed a sexual relationship with his minor daughter. Minor daughter. When the next that that after coming to know uh, about about the relationship and giving a mobile phone to his minor daughter by the informed handed over the aforesaid mobile access to the head teacher of the school, the principal of the school, wherein his daughter was studying. That that it is realized that that accused applicant, in spite of getting married to his daughter, had planned to get married to another girl, and on and after knowing about that, what is minor daughter that permitted suicide. Police on receipt of the FIR has registered the FIR police registered the police evidence for 6 under that convention section. Ms. S. Nawaz, the other parts of the that submits that 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 there was no active participation from the side of the accused applicant. In fact, the girl wanted to have some relation, have a love relationship with him, which the accused applicant had declined. And he submits that he submits that such such action of the accused applicant cannot be termed as abetment to suicide of the accused girl in the instant case, and therefore he submits that the accused applicant should be granted the privilege of pre-arrest bail. Case diary in the instant case has been used, and the same is produced. Insert the DP Goswami, the learned APP, on the other hand, submit for the submission against the accused applicant, therefore opposes the bail application, opposes the prayer of bail, pre-arrest bail application. This court has got the case diary minutely, and having found time of sufficient against the accused applicant, is not inclined to grant any relief to the accused applicant in view of the person, it's the application is.
Detail.
Yes, sufficient material.
I have instruction from the petitioner to withdraw this.
You are Mr.
KK Handicap.
Mr. KK Handicap, absolutely for the accused applicant submits that he has instructions. He has instructions to withdraw the instant AB application. Is that is received to be sent back? Then you write in view of the aforesaid sufficient, the instant AB application is dispensed as withdrawn.
Development. My please, Your Honor. So this pre-bail application, Your Honor. It's been 229 days, Your Honor, since FIR was lost. It's been 229 days, Your Honor.
For what?
Since FIR was lost. But
Then so you're still awaiting, then why do you want this bail to be granted to you? You are still avoiding arrest.
You know,
For last 1 year, you have been avoiding. But you go on avoiding, why do you need an order from the court?
nothing, nothing.
You are
is-
saying that the FIR was filed 200 and something days back, correct? Till now you are avoiding arrest. So why do you want an order from the court now? You avoid. You avoid the arrest. What, Mr. Goswami, what is there?
We have not received the case dialogue.
We have not received the case there.
You have not received the case.
Not
diary. Okay. Heard Mr. S. Nagdalanet appearing for the accused applicant. Also heard Mr. D.P. Goswami Lanet appearing for the state. Is that he is awaited? Let the matter be listed.
24/6.
Huh?
24/6.
24.
18, 18.
24/6. Is that he hasn't come? It's an application, Mr. Goswami.
Okay.
Make it on 18 or 19.
Right.
18. 18.
Rahman.
Lordship got information that the actual accused persons, main accused persons are allowed to go on bail. So kindly give time to place the.
CD has come.
Yes, come.
Main accused person is gone on bail.
Yes.
Where is the order?
Need time to place the order, Lordship. Taking time to place the order.
You're paying for adjournment.
What is there in the CD?
He was one of the person who has committed the offense. Three persons were arrested.
From the scope of the petitioner.
3 persons were arrested for
Three
what?
persons were arrested for along with some materials from rod and other materials for theft. And he was along with them, but the people apprehended the other persons because of their earlier offenses, and he fled away from the place somehow. That is the allegation against him, and now he is absconding from the date of occurrence.
Lordship is the business person with the scope of stone and bricks.
Primarily, all the materials are against the co-accused statements also there. He's
involved.
Yes, he's involved.
He's
He was
involved.
one of them, along with the 3 persons who were apprehended and arrested by the police. He was paid away for some.
He was also there in the.
He was there.
Somehow he managed
to escape.
Nothing is required from the house, from the shop of the petition. He has a shop of bricks and stone.
Heard Mr. Your name?
A is Ahmed.
A.H. Ahmed, the learned counsel, appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned DPP for the state. Is in application under section 482 of DNSS for paying for grant of clearance bill to the accused applicant in connection with pneumatic PS case number 73 stroke 2026 raised by under section 303/2 stroke 112/2 of DNS 20. An FIR was lodged on 5/5/2026 alleging stealing of a bundle of plots from the house of the informant. It was alleged that some of the accused persons were not red-handed. However, the accused applicant somehow managed to flee. The case that in the instant case has been received and seen is produced. After finding sufficient implementing material against the accused applicant in the instant case, the instant bail application is rejected. So
Service is incomplete in respect to expert number 2.
the service report is awaited. Let the matter be listed after 2 weeks. Now it is an IB application.
Yes, maybe not. Charge sheet is.
1 second. Is POXO or?
Not POXO only, the 376.
366 and
366A and 376.
The service is available. PCR, please. PCR along with the case that it's the service is awaited. Let the matter will listed in the next week. Let the matter be listed on 18 June.
Yeah, please, your lordship. Lordship, this is a bail application, your lordship. Lordship, may kindly come to page 30, FIR, 30. Type copy of the vernacular.
Yes.
Lordship, he was arrested on 8th May and today is 34 days complete. So he was, for one day, he was in the police custody. And perhaps, Lordship, he was sufficiently interrogated and rest 33 days in the judicial custody. And Lordship may kindly come to page 42, Lordship. He is a psychiatric patient, Lordship. Page 42. For the last 4 years, he was under the supervision of a psychiatric patient. Several documents I have annexed, Lordship, including his. And Lordship, during the time he was in the jail for 4 days, he was.
If you are released, then again these people will be in problem.
Lordship.
Now this is
Psychiatric person.
his family people will be in problem. Again, you will confine them.
We have to do something, Lordship, because some treatment has to be provided to him. And he was also in the
There's a risk to these people, no?
Lodge. And in the GMCH from 24th May to 26th May, he was admitted from the jail. Police admitted him into the GMCH. And he has, Lordship,
hepatitis C. He's a several diseases associated, Lordship. So whether his custody is required or not, Lordship, that is the question, Lordship.
Custody may not be required, but like releasing him will be a problem to those people.
Something has to be done, Lordship, for the betterment of his welfare of his other family members. Definitely, Lordship. Lordship is right. CD is available.
Yes, Mr. Das.
Lordship, what I have seen, Lordship, is true. What Lordship has think of that, Lordship. He used to, there is a conflict between his wife, with her wife, Lordship, and asking for 37,000.
Where does he work? Does he work somewhere?
Right now, he's not working. He's just taking shelter in his home, Lordship. He's a patient.
He's, I mean, who else are there? I mean, other than this?
His wife and mother, Lord. They are with him.
So they are also, their life is also in danger.
They are taking care of him, Lordship. But it is not that he is always harassing
But
them.
this was filed by whom? FIR was filed by whom?
Police.
He also locked the police also, Lord.
Police went
He
there.
locked
And
police on the officers also, Lordship.
And what happened to this Saira Begum?
It is given bail, Lordship.
Huh?
As
She was
because of her
given bail.
old
She was-
age, Lordship, she has given only 35(3) notice and asked to cooperate with the investigation because of her age, Lord.
she was allowed to go from the Thana. Yes, police station. His mother.
One, three populations. Productive. Eight, accused, one, two, six. Five populations. Now draws by W X I in the P duty by of before the official in charge of paid by individuals. Upon receipt of traffic information about the quarrel between husband and wife, the police, including went to the place of occurrence, namely a prior presidency block B dash 404 transport Vatican and on the flat lock semicolon that while they were waiting one person, namely Niaz Akhtar Ahmed. Niaz Akhtar Ahmed from the accused arrived at the place at after the police requested the report. They went inside the flat and found two ladies inside the flat. That one of the ladies, namely Sayada Farida Dilsa Hussain, intimate the police person that her husband, her husband, namely Niaz Akhtar Ahmed, had engaged in an argument with her and she had been wrongly confined inside the flat. That the police chief wanted to rescue the soldier inside the ship. But the accused applicant Dr. Ahmed did not allow the police person to do so. In fact, assault the police person using a reason weapon. Of the state of the police register. The article of PH is by PH and the public etc. The learning counts in this subject has been suffering from a psychiatric problem for the past 5 years, and he has been on off medical on and off hospital and medical colleges. He further submits that the accused applicant had not described more than 50 inside the and partly for the of the accused applicant cannot be required. Which is that in CDS come no, but is there anything incriminating?
Otherwise, look, that something is there, look, in the, what is in the FIR?
Nothing else.
Nothing else. Only the police has, because they have obstructed them.
Is that in that? Description of
Chief Judicial Magistrate Kamrup Metro.
Chief Judicial Magistrate Kamrup Metro. Subject to the condition that the corporate and make himself available as and when required by the investigative office. In the above terms, the instant verification is allowed.
I'm deeply obliged, Lord.
So,
Senior sir is on his way.
Huh?
Senior sir is on his way. He was stuck.
He has already completed his
I will only take 1 minute to show 3 documents.
No, you have already completed, Mr. Das. We cannot allow you go on and go on. Let them reply, submit, then you reply.
Right.
Let them submit, then you reply. Yes, madam, what happened? We cannot keep waiting just like this.
Call please. Then can you pass over the matter for the time?
Pass over for time. Yes, come, yes. Come.
I'm sorry.
Yeah.
But the petitioner's side have relied on various decisions. And the decision logic has already placed. The first is for the PT Anthony. But my submission will be lot. Ultimately, the case of the petitioner is that because this is the same transaction.
Because see, I'll tell you what he argued.
Lot.
He said there is one RFP. Correct. One RFP was plotted, and one of the companies like which is owned the I mean contract is he belongs to him.
Okay.
Then there was some illegal, and this company was providing this this training, this professional training to lot many people. Lot many people in different districts. Now there are allegations about misappropriation of some money by faking their identities and whatever. Some allegations are there.
Yes.
Like then four FIRs have been filed. Four FIRs have been filed in different places.
Yes.
Now there are 4 places. Now he is saying that his argument is that like it is the same transaction and the same allegations are same amount involved. So therefore, rather than having these 4 different FIRs in different places and separate investigations, why can't we have one investigation clubbing all the 4 FIRs together? That is his argument. And in that in support of his that argument, he has placed those cases.
That's lot. The right from TT Anthony's decision and the Babu Bhai and other decisions till 2026, one decision is there. They have placed. Look, the ultimate test is whether whether this is the same transaction or there is commonality is there or not. That is the basic taste.
Yeah, the term they have used sameness.
Sameness. So here, in fact, there are 1819 of the TT Anthony's case. That is the case. And in fact, in 2026, the decision they have relied. The conclusion of the Honorable Court is in para 25-26. Ultimately, Honorable Court has said that permitting multiple affairs and investigations in different jurisdictions on the same set of facts would not only contribute to the settled legal position, but it will result in avoidable multiplicity of proceedings, conflicting findings, and serious prejudice to the petitioner. So therefore, the ultimate thing is whether this transaction is common or not, that ultimately will not be. I'll place reliance on 2 decisions of the Honorable Apex Court. Madam, kindly, I have given the copy. 2013 6 SSC. Then while the examining, Lordship will see in what manner the commonality has to be seen. Para 2013, I'll refer to para 1-8. 1 is the fact, 8 is the issue. Then 14-15, final paragraph is 42-43. Kindly permit me to place.
Yes.
The issue in this case is the leave granted the para 1, the cardinal question of public importance, and one that is likely to arise more often than not in relation to lodging of the first FIR report, the first information report, with the aid of section 156(3) of the Code of Criminal Procedure, or otherwise independently within the ambit of section 154 of the code is as to whether there can be more than one FIR in relation to the same incident or different incident arising from the same occurrence. Then kindly come to para 8 of this decision. The issue there Lordship has noted. Finally, here a High Court has allowed the registration of 2 FIRs. In this case, Anju Chaudhary, Lordship has the High Court has allowed the registration of 2 FIRs. That was challenged before the Honorable Supreme Court. Kindly come to para 8. In the present appeal, by way of special leave, the appellant Srimati Anju Chaudhary challenges the legality and correctness of the order of the High Court, primarily on the following grounds. 8.1. The order passed by the learned CJM dated 29/7/2008 did not suffer from any error of jurisdiction, and thus the High Court could not have upset the said order in exercise of revisional jurisdiction. While making certain observations, the High Court in the impugned order held that prima facie cognizable offences were made out, and while virtually directing the learned magistrate to get an FIR registered, has foreclosed the exercise of judicial discretion by the learned magistrate. As such, the order of the High Court is not sustainable. In law, there cannot be 2 FIRs registered in relation to the same occurrence of different events or incidents, 2 or more, but forming part of the same transaction. The direction to register a second FIR, therefore, is contrary to law and the very spirit of section 154 of the code. The order of the High Court is in violation of the principles of natural justice, inasmuch as the High Court neither gave any notice nor heard the appellant before passing the impugned order dated 26/9/2018. So this was challenged before the Honorable Apex Court. Kindly come to para 15. Honorable Court, while deciding this, has noted that it has to be examined on the merits of each case, whether a subsequent
Para 14.
para 15. 15. Got it. Para 14 also, Mullah?
14 you are not ready. 14 you are not ready.
I'll read. Para 14 and 15. On the plain construction of the language and scheme of section 154, 156, and 190 of the code, it cannot be construed or suggested that there can be more than one FIR about an occurrence. However, the opening words of section 154 suggests that every information relating to commission of the cognizable offense shall be reduced into writing by the officer in charge of a police station. This implies that there has to be the first information report about an incident which constitutes a cognizable offense. The purpose of registering the FIR is to set the machinery of criminal investigation into motion, which culminates with filing of the police report in terms of section 173(2) of the code. It will thus be appropriate to follow the settled principle that there cannot be 2 FIRs registered for the same offense. However, where the incident is separate, offenses are similar or different, or even where the subsequent crime is of such magnitude that it does not fall within the ambit and scope of the FIR recorded first, then a second FIR could be registered. The most important aspect is to examine the inbuilt safeguards provided by the legislature in the very language of section 154 of the code. These safeguards can be safely deduced from the principle akin to double jeopardy, rule of fair investigation, and further to prevent abuse of the power by the investigating authority of the police. Therefore, second FIR for the same incident cannot be registered. Of course, the investigating agency has no determinative right. It is only a right to investigate in accordance with the provisions of the code. The filing of the report upon completion of investigation, either for cancellation or alleging commission of an offense, is a matter which once filed before the court of competent jurisdiction attains a kind of finality as far as police is concerned, maybe in a given case subject to the right of further investigation, but wherever the investigation has been completed and a person is found to be prima facie guilty of committing an offense or otherwise, the examination by the investigating agency of it on its own should not be permitted merely by registering another FIR with regard to the same offense. If such protection is not given to a suspect, then possibility of abuse of investigating powers by the police cannot be ruled out. It is with this intention in mind that such interpretation should be given to section 154 of the code, as it would not only further the object of law, but even that of just and fair investigation. More so, in the backdrop of the settled canons of criminal jurisprudence, reinvestigation or de novo investigation is beyond the competence of not only the investigating agency, but even that of the learned magistrate. The court have taken this view primarily for the reason that it would be open to the scheme of the court and more particularly section 167(2) of the code. 15. It has to be examined on the merits of each case, whether a subsequently registered FIR is a second FIR about the same incident or offense, or is based upon distinct and different fact, and whether its scope of inquiry is essentially different or not. It will not be appropriate for the court to lay down one straitjacket formula uniformly applicable to all cases. This will always be a mixed question of law and fact depending on the merits of a given case. We finally come to para 42 now. But what is the common? The does 42 does. We are called upon to deal with from the point of view as to whether the investigating agency should be restrained from conducting further investigation, or there should be stay of such investigation. It is true that law recognizes common trial or a common FIR being registered for one series of acts so connected together as to form the same transaction as contemplated under section 220 of the code. There cannot be any straitjacket formula, but this question has to be answered on the fact of each case. This court in Mohan Baitha versus State of Bihar held that the expression same transaction from its very nature is incapable of exact definition. It is not intended to be interpreted in any artificial or technical sense. Common sense in the ordinary use of language must decide whether or not in the very facts of the case, it can be held to be one transaction. It is not possible to enunciate any formula of universal application for the purpose of determining whether two or more acts constitute the same transaction. Such things are to be gathered from the circumstances of a given case, indicating proximity of time, unity of proximity of place, continuity of action, commonality of the purpose or design. Where two incidents are of different times with involvement of different persons, there is no commonality or the purpose thereof different, and they emerge from different circumstances. It will not be possible for the court to take a view that they form part of the same transaction, and therefore there could be a common FIR or subsequent FIR could not be permitted to be registered, or there could be a common trial. Similarly, for several offenses to be part of the same transaction, the test which has to be applied is whether they are so related to one another in point of purpose or of cause and effect, or as principal and subsidiary, so as to result in one continuous action. Thus, where there is a commonality of purpose or design, where there is a continuity of action, then all those persons involved can be accused of the same or different offenses committed in the course of the same transaction. And because of these reasons, for the reasons aforesaid, we find no jurisdictional or other error in the judgment of the High Court, and that leads us to direct dismissal of this appeal. So ultimately, considering the facts of that particular case, the Honorable Court has dismissed this SLP, and that two FIRs which the Honorable High Court has directed in that case is permissible. In my case, kindly see, they were given a contract, but they were running the training centers at different places for different persons at different places. The victims in Mongoldo in Dhula police case, Dhula police station case are different. Centers are being run by different persons at Dhula. Some persons are agreed in this book. Some are agreed at the Tihu. So they are running the centers from different places for different persons, and the affected persons are also different. They cannot say, well, although the nature of the fraud, the activity is same, but the transaction is not same. My responsibility, because the test which Honorable Court has discussed in para 43 and 44 of this petition, kindly see, if we apply that the two acts constitute the same transaction, the same such things are to be gathered from the circumstances of a given case, indicating proximity of time, unity or proximity of place, continuity of action, commonality of purpose or design. Where two incidents are different times with involvement of different persons, there is no commonality, and the purpose thereof are different and emerges two different offenses. So therefore, two FIRs can be launched. To separate investigations in such a case is required. The second
But in your FIRs, the allegations are
totally ditto.
Allegations are
There is no, I mean, there is this much of money, this much of money, true. Say,
because the
only difference is that like now, I mean, I'm not commenting on the marriage. Only this thing is that apparently it has been seen.
But
Difference is that like, obviously like this, the affected persons are obviously different from different villages and different districts. And secondly, these centers, they may have given it to somebody else. Somebody else is running the center. Is it so?
No, no, no.
Or you are running the center?
Yes, yes, ma'am.
You are running a center of your own?
Sir, yes, ma'am. We have taken.
You are not subletting in your,
No,
like
ma'am.
subcontracting it?
No, ma'am.
directly,
No, ma'am.
the local team.
No, ma'am.
You are yourself, you are doing.
Yes, ma'am.
they have their different people.
And there were no
different things.
centers in dispute jurisdiction. No centers in dispute jurisdiction. Ma'am. Only the head office. No training was provided under the jurisdiction of dispute police station.
No,
No training centers were there in the basic jurisdiction of dispute police station. Ma'am.
okay.
No training was imparted.
But
in
your head
documents.
office is in dispute.
Yes, ma'am.
Head office is in dispute.
Yes, ma'am.
But like in other places, there are training centers.
Yes, ma'am.
In Tihu,
In Rongia, in Bhikyajuli.
Getting the
This scheme provides for a particular benefit, and that benefit is suppose 1,000 rupees or 1,600 rupees. It is common for all the beneficiaries. 1,600 is common for. Therefore, the allegation is similar. Lordship, kindly take up the second decision, Madam.
yes.
Promote Saxena, 2008 9 SSS 685. In that case, well, in fact, here the petitioner, he was in jail. And he was in jail. While he is in jail, several cases were there at different places. And one of his prayer was that to club all the cases. That was rejected by the court. Kindly take up para 25. I'll rely on para 25, 26, and 27. His prayer for clubbing the case was rejected. I'm just tracing that. Facts, I'm not taking your logic. Broadly, that is the fact.
Yes.
Para 25. The learned counsel in this contention invited our attention to a two-judge bench decision of this court in V.K. Sharma versus Union of India. In V.K. Sharma, the petitioner was an accused in a large number of cases punishable under section 406, 409, 420, read with section 120B IPC in several states. There also, in spite of securing bail orders in his favor in some of the cases, the petitioner had to remain in jail in view of production warrants issued by other courts. The petitioner in that case too approached this court by filing a petition under Article 32 of the Constitution, alleging violation of his fundamental right guaranteed under Article 21 of the Constitution, seeking an appropriate redirection or order that he should be released on bail, and all cases pending in different states against the petitioner be consolidated in one of the same court, pro investigation by the CBI in all cases. Next para. This court considered the rival contention of the parties. It did not think proper to grant all relief sought by the petitioner, but granted the following relief to him. If number one, if the petitioner is arrested in connection with any criminal cases in his capacity as managing director of this JBG group of companies, the arresting officer shall release him on bail on his executing a bond to the satisfaction of the arresting officer. Such relief shall be made after getting the assurance from him that he will be present in the court concerned on the days when his case is posted. However, we make it clear that it is open to the petitioner to apply to the court concerned for exempting him from personal appearance on condition that a counsel on his behalf would be present on such posting dates, and he would not dispute his identity as the particular accused in that case, and further that he would make himself available on the date when his presence is imperatively needed in that court. 3. We permit the petitioner to move the appropriate high courts for bringing all the cases pending in different courts within the territorial jurisdiction of that court in one single court or more than one court, depending upon the number of cases or width of the area of the state is concerned. The order will come into effect only if the petitioner would surrender his passport in this case. The Shanti Bhushan Learned Council expressed a doubt that the petitioner would have already surrendered the passport before another court pursuant to the order passed. In that case, he can satisfy the Registrar General of this court by an affidavit of that situation in the Registrar General can
intimate the jail authorities concerned of that position, we make it clear that it is open to the investigating agency in any case to move for cancellation of bail if any such investigating agency finds that the petitioner is misusing the liberty granted by him. This court does in V.K. Sharma granted certain relief, keeping in view the fact that the accused in jail since about 16 months. The court further held that if the petitioner would be arrested in any criminal case in his capacity as managing director of the company, the arresting officer would release him on the executing a bond to the satisfaction of the arresting officer. Next para. The learned counsel for the respondent, however, referred to a decision of the three-judge bench of this court in state of Punjab versus Rajesh Shail. In Rajesh Shail, the respondent was a former director of a company. The company collected huge amount from the general public for purchasing land and promised that the amount would be returned after a period of maturity period fixed through checks. Monies were not repaid and complaints were made to the state. The Vigilance Department of the state lodged various FIRs against the respondent. According to the prosecution case, crores of rupees have been collected by the companies from the general public. Proceedings were initiated by the accused by filing an application under Section 482 of the Code of Court in the High Court for quashing of the criminal proceeding. A prayer was also made that all cases be tried in one court. Support was sought from V.K. Sharma, though in the decision V.K. Sharma, this court had stated that the order could not be treated as a precedent. The High Court, while treating the order as a precedent, allowed the petition of the accused and transferred different cases pending in the state of Punjab against the accused to a court of special judge. The said action was challenged by the state in this case. In this court, considering the relevant provision of the court, particularly relating to framing of charge and conduct of trial, this court held that in the light of various provisions and the scheme of the court, no direction could be given by court to consolidate all cases against the accused and to be tried in one court. Such a direction would be contrary to the express provisions of the court. Even in exercise of inherent power under Section 482, the High Court could not direct an authority to act contrary to law. This court also observes that this court has ample jurisdiction to pass order under Article 142 of the Constitution for doing complete justice between the parties in any case or matter, but it is doubtful whether the exercise of the said power, such an order could be passed. This court held that a direction so as to consolidate cases pending in different courts for different offences to be tried in a single court issued in V.K. Sharma was not in consonance with law. V.K. Sharma was therefore expressly overruled. So therefore, my submission is, in fact, the petitioner's prayer for consolidation of the cases in one court, that was not granted, although he was given some relief. Therefore, my respectful submission is, considering the nature of the offences alleged here, the taste which logic will examine that whether there is commonality or the sameness is there or not amongst the allegations which were registered against the petitioner. In my respectful submission, there is nothing common, although it is similar. This is not out of the same transaction because all the transactions are different. So the investigating authority may be allowed to investigate the cases on their own merit because the evidences at Dula, the persons will be different, their versions will be different. Let them investigate the case in Dula. Few persons will they may have different how they were the persons were taken into belief that they will be given the training and they will be given the benefits in Tihu. That will be spelled by Tihu people.
But how the prosecution will be prejudiced by that? See, I mean, whether you will be having any difficulties if you do it together.
But the law provides that
No, I understand your anxiety. I mean, like there are different people are there, the different transactions you are saying. Cases are filed in different localities. So investigation has to be done by the respective police.
Yes.
But now if we are just asking, I'm just asking, if all the cases are brought into one police station, and an investigation is carried out from the particular police station, will there be any prejudice caused to you, the state?
Well, in fact, in the on the point of prejudice, my lord, they ultimately, if the school police, suppose this Lordship has consolidated direct to consolidate it in Dispur P. Ultimately, the Dispur police has to go to Dhula and find out who are the people in agree in Dhula. They have to go to TU and find out what is the version of the TU. Or if they issue notice to the witnesses, the people.
The victim has to come.
Victim has to come to Dispur. Ultimately, the fact situation, the ground realities in Nalbari will be different, in Dhula will be different. And if at all the FIRs are I'm not without any prejudice, I'm making sufficient. If at all the petitioner finds that there is no material on the allegation, this is not a quashing petition. This is simply a prayer to consolidate all the.
Yes, they haven't come for.
No. So on merit, at this stage, although he has made some petition, I'm not taking a lordship to the merit. We are at this stage of investigation. And this case was filed in 2022. We are on 2026. Lordship has directed the case diaries to be called for. Case diaries are with us. Investigation is not going ahead because the case diaries, in fact, the government has taken a decision to speed up all the old investigation, and they have written me 2-3 letters. And I have informed them that no, this case is pending. The Honorable Court has directed us to keep the case there because it has been proceeded to the court.
So no. What was the reason for calling for the case diary?
Lordship wants to see how the investigation was progressed, or that may be the reason. And submissions are being made by the petitioner that cases are registered. There is no.
Okay, what is the stage now in the investigation?
Some the diaries are some at the initial stage, some statements were taken.
Some statements have been taken, but not much.
No.
Gone ahead.
No, in the meantime, the case came.
So nothing much has progressed in each of the cases because of the case pending here.
Because yes, all four diaries are lodged at court.
Yes.
So this is my respectful submission.
Because it is basically a law point. I mean, that has been decided.
Yes, Malad. Yes, Malad. The commonality test has to be lodged to see that, and if lodged finds that these are same transactions, Malad, in Titi Anthony's case, it was a firing incident. In that incident, a lot of people, Malad, they got injured.
Yeah, I understand.
Malad, from both sides, FIRs have been filed. Lordship has said that no, one FIR investigation will cover it. All those cases are there, but these offenses are different. These are real victims are different. Their stories will be different. Ground realities and Mongoldo will be different. Nalbari will be different. I don't know what type of promises or what type of statements the beneficiaries were they were attracted for trading, and how it was done. They were reported. Things will be different. Investigation will take long.
Well, so far as the Rongia police station case is concerned, well, the question is, what was the rationale for the state to transfer the Rongia police station case to Dispur police station case? And my lord,
whatever happened.
Now two cases has already been consolidated, my lord. Out of 4, 2 has already been clocked and brought to the jurisdiction of Dispur police station. And my lord, there was application twice, my lord, by the state to transfer Rongia police station case to Dispur police station. So far as the stand taken by the state is concerned that the victims are from a geographical area of a particular police station. So therefore, it will not be proper to send the Dhula people or the two people to subject to jurisdiction of the Dispur police station case. Now, the same principle would also apply for the people of Rongia police station, my lord. So necessarily, my lord, what would be the outcome of such a situation will be
there will be a class within a class. And that will directly infringe Article 14, my lord. Because, my lord, Rongia police station case, my lord, the victims, alleged victims, and the two police station case victims are a class within itself, my lord. They are belonging to the same class.
Why are you bringing in this class within class?
Yes, my lord, because the differential treatment
What
carried out by the state,
Hmm?
the differential treatment carried out by the state were the residents and complainants of Rongia and Dispur police station case.
We'll do one thing, we'll pass an order to say that like Rongia police station case will go to Rongia, Dispur will stay in Dispur, and other cases will stay on Dispur. Then there will be no
Even
class.
then, there is a difficulty, my lord.
Then
Because
there will be no, that is what you are arguing.
no, my lord, even then there will be
You
a
are
difficulty.
arguing that you are arguing that like why Rongia has been brought into Dispur. So that is a class within class will happen. Then there will be prejudice will be caused to some of the people of Rongia or maybe Dispur. So that then we'll segregate all the cases. Then let the cases be there where it was. Then what is the problem?
Yes, my lord. Even then there is a problem, my lord.
No,
Because
then what? Then, see, don't argue both the sides. If you argue one side, you must argue one side. Don't say that this is also correct, this is also correct. Then it becomes confusing, and then it will not convince me.
My lord,
Okay.
so far as Dispur police station case is concerned, my lord, the complainants are from Bayhata, Sarial and Rongia. None of the complainants from Dispur police station case are residents of Dispur, and the training was also not imparted within the jurisdiction of Dispur police station case. So, my lord, assuming, my lord, there are common complainants in Dispur police station case and Rongia police station case where they are residents of Rongia and the training also happened in Rongia. So, my lord, so far as the Rongia people are concerned, my lord, half of the people will be investigated by Rongia police station, half of the people will be investigated by the Dispur police station. And, my lord, so far as the transfer order is concerned, my lord, the transfer of the case is concerned, that is by the state. And that order is not being set aside and neither challenged by any of the parties. And so far as clubbing of FIR is concerned, my lord, I have documents to show the test of sameness which has to be applied. And the scheme of the act was under one NIT. The payments, my lord, the grievance of the victims are we were the beneficiaries, but we did not get the necessary payments. Therefore, my lord, I was referring to only two pages, my lord. Page 218 of my petition, my lord. Only to show, my lord, that the payments were made from a single jurisdiction everywhere. My lord, kindly have 218. This is the RTI reply, my lord. 218.
Yes.
My lord, one, as per official records, reply number one, as per official records, the wage compensation amount which is being paid to the trainees of skill development training program phase 1 was paid by this office. Well, this office would mean the office of the Labor Welfare Department, which is situated at Gauhati, my lord, which is paid by this office through direct bank transfer to the respective bank accounts. So, my lord, this becomes the same transaction. Two, as per official records, the wage compensation amount which is being paid to the trainees of skill development training program of phase 1 was not given to the training service provider at any given point of time in the skill development training program. 3, as per official records, the beneficiary list of trainees of skill development training program who are given stipend for the training is uploaded in the website, and this is the list. So, my lord, reply number 1, it is very absolutely clear, my lord, that the payment was made from one single source, from a particular office in Gauhati, and that squarely covers the theory of same transaction. And, my lord, next page, my lord, 219. As per official records, the wage compensation of 280 per day, which is being paid to the trainees of skill development training program phase 1 and phase 2, is paid by this office. My lord, kindly note, by this office through direct bank transfer and PFMS portal to the respective bank accounts. As per official record, the wage compensation amount of 280 per day, which is being paid to the trainees of skill development training program phase 1 and phase 2, is not given to the training service provider at any given point of time in the skill development training program. The payment was never routed through the training provider, my lord. As per official records, the payment of wage compensation of 280, which is being paid to the trainees of skill development training program of phase 1 and phase 2, is done on the basis of actual biometric attendance of trainees. And all of the biometric attendance of trainees, my lord, are verified by that office. And after that verification, the payment is released from one single source. My lord, the next page, my lord, page 220. In both phases of skill development training, phase 1 and phase 2, Assam Building and Other Construction Workers Welfare Board, the verification of the attendance submitted by the training service provider in skill development training are done by checking the actual biometric attendance of the trainees, which is verified by the respective registering officers and the training center managers. On the basis of such actual biometric attendance, the criteria for selecting eligible trainees for stipend and training service provider payment is finalized. My lord, the last line, my lord, this finalization takes place in the office of the Labor Welfare Department, which is situated at Gauhati. So, entire training, my lord, whatever the stipend, whatever the benefits has been released through direct bank transaction, DBT mode, my lord. And the payment was done by the government department itself from one single source. So that squarely covers my argument of the test of sameness to be applied in this case. And so far as my argument, so far as Article 14 is concerned, why I was pressing that argument, my lord. Yes. Madam, may kindly appreciate, my lord, the basis on which the complainants of Rongia and Baihata Sariali have been secluded and given a differential treatment, my lord. That is the larger question to be.
You should not be bothered about that.
My lord.
It is not, if they are having some problem, they will come to the court.
My lord.
It's not your lookout.
My lord.
It's not your lookout. Your lookout is not that if they are aggrieved that they are not given equal treatment by giving different investigations, then they will come to the court. Who are you to say so?
My lord.
You are a person who has been alleged of doing some misappropriation.
My lord.
And now if you want to argue for them, the victims, then it's a different case. Then you'll have to release that and go through that victims.
My lord, I was not on that. My lord,
no, you are arguing that that the victims will be differentially treated because they will be having a different investigation and other people will be having a different.
No, my lord.
The Rongia people will be investigated by dispute police. Dispute police will be investigating these people.
My lord, this is quite the accused, my lord. The right to investigation, my lord, right to fair investigation is as much as a right available to the accused, my lord.
What your problem in that? How you will be different? You will be differentiated.
My lord, the test of sameness, my lord, with greatest of respect, my lord, it cannot be applied with two yardsticks. But the test of sameness has to be in a single parameter, my lord.
Test of sameness of the grievances.
Yes,
allegation.
Yes, my lord.
So,
my lord. And so far as
allegations and grievances are same,
yes,
and they should be clubbed together. That's what the
yes, my lord. Yes. So far as
yeah, I mean, you are saying that you will be treated as different class when you are the same person. You are not a different person.
No, so far as the investigation is concerned, my lord, that was only my. Yes.
You are the person who will be investigated. Correct.
Yes, madam.
So you will be investigated by dispute police. You will be investigated by other police station also. Then how you are saying that Article 14 will be violated for that?
Well, because there is no rationale why the Rongia police station case would otherwise be transferred to dispute.
No, forget about that. Now, if Tihu police wants to do some investigation,
my lord,
in an FIR, and Rongia police wants to do some investigation in the FIR lodged in Rongia,
How there will be like a particle fucking while?
Well, the test of sameness has to be applied, my lord. Because in the last judgment, my lord, of the Supreme Court, my lord, the incident related to a real estate, my lord,
That's a different
issue.
thing, real
My lord, the complainants were from different parts, my lord. Complainants were from different parts, from different
parts,
states.
but they bought the house, their flat in the same society,
My
the
lord,
same place,
My
from the same owner.
my lord.
That is why they have said ki like that. I mean, it can be clubbed together. It cannot be different. That's a different thing altogether.
My lord.
Your case is different.
My lord,
Let's
so
see,
far as
Lisa,
the
I'm not commenting anything
Yeah.
on merit. I mean, we'll see. We'll touch it.
because the payment was also made from one single source, my lord. And my lord, kindly appreciate, my lord. There are several other training programs which were carried out under this phase one, my lord. Now, each individual, my lord, if files a separate complaint under 19 different districts, my lord, this is where the law protects me, my lord, that I should not be subject to harassment from 19 different police stations. Because there has to be a test which has been laid down in those three judgments which I have already placed. The test of sameness has to be applied. And in my respectful, humble submission, my lord, the facts of this case and the nature of the work which was carried out by the training service provider squarely falls, my lord, under the test of sameness. And so far as Article 14 is concerned, my lord, I had 2-3 judgments. If my lord permits, I can place them.
But 14 is not violent.
Can we have a
Article 14 is not violent.
only 10 minutes, my lord? I only placed 2-3 judgments.
You place.
Yeah. My lord, this is 1983 4 SCC 225, paragraph 9, my lord.
Yes.
What then should be done? The appellants have been accused of participating in a procession taken out by the members of the police force for ventilating their grievances about their service condition, maybe that still have not reached the stage of tolerance for formation of association amongst police personnel. The demonstration may be looked upon with disfavor. But approaching the matter from this angle, all the 1100 dismissed members of the police force were guilty of same misconduct, namely indiscipline to the same extent and degree as the present appellants. Now, if the indiscipline of a large number of personnel amongst dismissed personnel could be condoned or overlooked, and after withdrawing the criminal cases against them, they could be reinstated, we see no justification in treating the present appellants differently without pointing out how they were guilty of more serious misconduct or the degree of indiscipline in the case was higher than compared to those who were reinstated. Respondents failed to explain to the court the distinguishing feature, and therefore we are satisfied in putting all of the same in the same bracket. Pausing for a moment, my lord. The distinguishing feature.
Give us the facts. What was the fact?
My lord.
Facts.
This facts is paragraph 9, my lord.
Facts. Give me facts. What?
My lord.
Paragraph 9 facts.
My lord.
Give me the facts. What happened? What happened in the case?
My lord. My lord, may kindly have paragraph 2. To begin with the factual matrix. Dissatisfaction about the conditions of service of member of the police force in the state of Punjab led to an agitation which at its height was in the form of a procession and some demonstration. The state of Punjab initiated disciplinary action and dismissed about 1100 members of the police force on the ground that they had participated in an agitation which was impermissible under the rules governing the discipline in the police force of the state of Punjab. A number of criminal prosecutions were filed against participants in the agitation. Some of the members of the police force who were dismissed from service filed writ petition in the High Court of Punjab and Haryana, but were dismissed. It appears that after the dismissal of the writ petition, about 1,000 former members of the police force were reinstated and criminal cases pending against them were withdrawn. In this behalf, the submission of the state of Punjab is that a committee consisting of members of the superior rank of the police force was constituted by the state government to review the cases of the dismissed agitators, and reinstatement followed on the recommendation of the committee. We will have occasion to revert to the aspect of the matter later on. The committee consisted of Director General of Police, Deputy Director Inspector General of Police, Assistant so-and-so and Superintendent of Police District to which the dismissed members of the police force belong. It is conceded that of the 1100 dismissed agitators, 1000 were reinstated and the rest were left to fend for themselves. Those who were thus weeded out of the committee by the committee filed writ petitions before the High Court of Punjab. A division bench of High Court dismissed the petitions, making the following order. Now, this is the fact of the case.
So it is.
And under this fact, my lord, kindly have paragraph 9 once again, my lord. The respondents failed to explain the court the distinguishing feature, and therefore we are satisfied in putting them all in same bracket. Here also, my lord, the distinguishing feature, so far as Rongia complainants are concerned and Baihata complainants are concerned, and why they should be investigated by Dispur police station, my lord, that distinguishing feature has to be explained. Otherwise, the same yardstick will be applicable to Rongia and Pihu and Dhula. On that conclusion, my lord, the treatment meted to the present appellant suffer from the vice of arbitrariness, and Article 14 forbids any arbitrary action which would tantamount to denial of equality as guaranteed by Article 14 of the Constitution. The court must accordingly interpose and quash the discriminatory action. And my lord, so far as the action of the state to transfer the two cases to Dispur, my lord, that would amount to indirect discrimination, which is also recognized, my lord. I will only place two paragraphs, my lord, of because there is some reasons has to be stated, my lord, why this differential treatment, why I should be subject to investigation of two incidents, two FIRs in one police station and two others in separate police stations.
Because those were filed in those respective places.
But in Rongia, my lord, those were filed in Rongia. Why the Rongia was transferred to Dispur, my lord, without any reasons, my lord? That here, my lord, the test of reasonableness has to be satisfied. My lord, may kindly have paragraph 49, my lord.
What is the stand? Why it was transferred?
No,
You filed an affidavit, no? What is the stand in that? Why it was transferred from initially from Dispur to Rongia, again Rongia from Dispur?
Lot.
Just have a look.
Kindly come to para 131. 131.
131 of your affidavit.
Yes.
Page 131.
Page 131. Yes. It starts at page 130. Para 3 Roman 1. Relevant page is 130.
Yeah.
Para 3
Yes.
Roman 1. We have said that as regards the statement made in para 7 of the petition, the deponent makes a state that one FIR being Dispur PS case number 2098 of 2022 under section so and so has been received by the answering respondent on transfer which was registered as Romeo PS case number 73 of 2022 under section so and so. So Dispur police has received this on transfer. Earlier it was filed in Romeo. As regard the statements made in para 8 of the writ petition, the deponent begs to state that after conducting investigation of the said FIR, that is Romeo PS 673 of 2022 under section so and so, it was again transferred to Dispur due to want of jurisdiction by order dated 17/12/2022 as prayed as prayer made by the IO before the learned court of subdivisional magistrate Romeo. It was transferred because of the 17/12 order.
Now, why it was transferred? What was the reason?
17/12 order, the in the case that it is, I'm just looking at the order. Then the different vexel para 3 different vexel state that on 26/9/2022, another FIR was received by the answering respondent, which was registered as Romeo case number 596 of 2022 under section 120. The 120B so and so, the answering respondent begs to state that after investigation, it was found that the place of occurrence does not fall within the jurisdiction of Romeo PS. As such, the said FIR was transferred to Dispur PS. So both the Romeo cases, 673 Romeo PS case number 673 of 2022 and subsequently Romeo PS case number 596 of 2022, both are transferred to Dispur.
But this was also passed by some order 29/10/2022 of subdivisional magistrate.
Yes, it's 29/10/2022. The order.
What was the ground taken?
The order is available here. But the order says the
order dated 17/12.
29/10/2022.
What does it say?
Since the prayer of SI Samarjuti Deka of this instant case of Romeo PS as well as peruse the same, the prayer is made for passing an order to transfer this instant case to Dispur PS, stating that during the investigation it has come to light that the place of occurrence of offense of this instant case falls within the jurisdiction of the said PS. Peruse the CR as well as the case diary placed before me. As such, considering the facts stated, prayer of the IO is allowed. Transmit the case record of OC Dispur PS for his needful doing. OC Romeo PS is asked to hand over the case diary as well as other articles related to this case.
The place of occurrence where? Dispur.
They said the IO of Romeo PS case said that it is the place of occurrence is Dispur, therefore case is transferred to Dispur.
But he's saying there was no listing in Dispur.
Yes, ma'am. It happened twice. And even the letter of complaint says so, ma'am.
There are two cases. There are two FIRs in.
Yes, sir. There was one FIR in Dispur first. Correct. That FIR was transferred to Rongia. Then the same was again transferred to Dispur. And one FIR in Rongia that has been transferred to Dispur. Two FIRs.
Logic.
Correct. One FIR was initially filed in Dispur that was transferred to Rongia and that has been sent back to Dispur again. And another FIR which has been filed in Rongia that has been sent to Dispur. Saying that there is no jurisdiction because the thing is not there.
Possibly in that investigation, the IO finds that the officers and all these things are in dispute within the jurisdiction of Dispur.
Do you have this order? Is a see this 17/12 order?
17/12.
Some light can be brought in.
I have the 17/12/22 CR put up today before me as the learned area magistrate is on leave. Since the prayer of the IO of this instant case, Suleiman Ali of Romeo PS is the same. The prayer is made for passing an order to transfer this instant case to Dispur police station, stating that during the investigation it has come to light that the place of occurrence of offense of this instant case falls under the jurisdiction of the state police station under Kamrup Metro District, periodic CR as well as the case that it placed before me. Considering the stated facts, prayer is allowed. The IO is at liberty to transfer the case. The investigation officer in charge of Romeo Police Station is to receive back the case diary, case record from this court and send the same to the concerned PS along with the case diary immediately. Inform all concerned accordingly.
So what exactly they mean, demand, it could not be found out.
They said that
Now jurisdiction means what jurisdiction they do not have.
no, it is not stated.
The victims are from Rangia only.
And even the training centers, it is stated in the
Training
FIR.
center is also in Rangia. Then what jurisdiction they are talking about? Are they talking about because the head office is there in dispute or what?
Maybe my lord, ultimately,
If head office is the issue, then like all the matters should be transferred to dispute. What is the issue? Why it has been actually transferred? Nothing has come out.
no, my lord. Ultimately, the investigation will reveal a lot, and now in dispute PS case, these two cases not there. The investigation will reveal, my lord, but finally, lot people see in the FIR what is the allegation. My learned friend is referring to page 218, 19, and 20. What is the allegation against that? That they have my lord, made false videos, false photographs, which shows that imparting of training. 2-3 days training they have given. They have shown that they have given training for.
No, allegations are very allegations are quite.
So the videos, the training, imparting training, the videos and photographs were made at different places.
But another one more thing, this thing not that RTI reply that he has referred to.
RTI reply, logic.
He referred to some RTI replies.
Yes.
Here it is like the government officials are saying that no payment has been made without actual biometric attendance and training of the training.
Malad, this is an RTI reply obtained in the month of December 2022. And kindly see what is the allegation, because there lies the Malad catch. They have made Malad false videos, false photographs. That is the allegation. And Malad, the biometrics. So ultimately the investigation will reveal how the biometrics were collected.
That's why
because 1 to 10, suppose 10 persons are there in Dula. 10 persons they have shown, and 10 biometrics are coming on record. Now the beneficiaries in Dula said that I have not been given, I have not been given the training and all. So in place of that particular 1 to 10, suppose 1 to 5 have been given, 6 to 10 they have not received. So that will come in investigation only in place of them. Who has given the biometrics? Whose photographs have been collected by them and submitted for collecting the bill? Ultimately, those data will be collected by the petitioner. He has to upload it and for processing the bill.
The reason is that he is supposed to give for 30 days. He has given only for 3 days.
4 days. This is the victims are saying that ultimately, Lordship will see a mechanism has been put into place by the authority so that biometrics and all these things are there, not to misutilize the fund. And the allegation has come now that false photographs, false videos have been made. By whom? By taking whom? Not the actual beneficiaries. Some other persons may have been placed. That is the allegation, and that investigation is to be done. So the RTI reply is okay, Mala. That is the mechanism placed in court. But that has been violated.
That is why there are some government officials are also involved.
But allegations are against them also. In the FIR
government officials are involved. Because
allegations.
without them, they cannot do anything.
So investigation will proceed.
And okay, we will decide only on the thing of sameness. If it is sameness, then we'll.
My lord, at page 234, my lord, which I placed, my lord, page 234, the mechanism of the payment, my lord, is as such. Even, my lord,
those investigation will do. Don't argue all those things now. You will be also wasting your energy. Okay, don't now argue on the merit now, because there is no point arguing on those merits. That investigation will reveal. Investigation has not been completed as yet. There are certain allegations against you, and like don't try to show that you are a holy cow. You have not done anything. Don't argue on those points. Now argue whatever you are required to argue in this case. So you have argued your case, whatever.
So far as
as far as the merit is concerned, the investigation will reveal.
That is a different issue, my lord. Whatever had fallen from your lordship, my lord, so far as the Rongia police station, why it was transferred to dispute for want of jurisdiction, my lord, that is the core argument, my lord. That is my core argument. And that, my lord,
we'll see that.
My lord, if my lord permits,
we'll see. But
Should I mark the judgment?
What is this required? This judgment, what, for what?
My lord, this is SK Naushad. I have placed, my lord, paragraph 49 and
For what?
50.
49 and 50.
Yes, my lord.
For what?
My lord, this is indirect discrimination, my lord.
Indirect discrimination.
Yes.
What is indirect discrimination?
Yes, that has been dealt in this judgment, my lord.
Discrimination to whom?
To the, so far as the subject to correction, my lord.
You will be discriminated?
My lord, because I will be subject to investigation at different police stations, my lord, on the basis of the same transaction.
Because there are different crimes. Because you have committed different crimes in different places.
My lord, in different crimes in different places arising after the same transaction, my lord. There can be different incidents.
Maybe one.
This is what Babu Bhai, my lord, has clearly.
Maybe one RFP, but under one RFP, you have committed crime in different places.
My lord.
Involving different people.
My lord. And the payment mechanism is also from one place, my lord.
4950, huh?
Payment mechanism is also from one place.
You are smart enough to do it from one place only.
My lord, this is not me, my lord. The payment was made by the state, my lord.
Correct.
It was never routed to
The state is also involved.
My lord. So, my lord, for the benefit of investigation, my lord, all these investigation, my lord, has to be clubbed together.
It's a mistake, but if you want to see, you always argue. I mean, the cases which are very apparent,
my lord,
and you want to show that like your client is a holy cow. Correct. It is not always correct. So you argue on the merit of this case.
My lord, kindly have paragraph
Don't
49.
go to other things now.
My lord, you kindly have paragraph 49. S can also. Paragraph 49.
40 and 49 and 50.
50. Yes.
Yeah. Yes.
In a recent judgment of a two-judge bench of this court in Lieutenant Colonel Nishita versus Union of India, of which one of us, Justice D.Y. Chandrachud, is a part, the court emphasized that discrimination, both direct and indirect, is contrary to the version of the substantive equality under Article 14, 15, and 16 of the Constitution. Elaborating on the doctrine of substantive equality and its engagement with discrimination, both its direct and indirect form, the judgment of this court takes due account of ground realities founded on the socio-economic structure of the society. In Nishita, this court held, recognizing that certain groups have been subjected to patterns of discrimination and marginalization. This conception provides that the attainment of factual equality is possible only if we account for these ground realities. This conception eschews the uncritical adaptation of laws and practices that appear neutral, but in fact help to validate and perpetuate an unjust status quo. Indirect discrimination is closely tied to the substantive conception of equality outlined above. The doctrine of substantive equality and anti-stereotyping has been a critical evolution of the Indian constitutional jurisprudence on Article 14 and 15. The spirit of these tenets have been endorsed in a consistent line of authorities by this court. To illustrate, in Anuj Garg versus Hotel Association of India, this court held that laws premised on sex-based stereotypes are constitutionally impermissible in that they are outmoded in content and shifting in means. The court further held that no law that ends up perpetuating the oppression of women could pass scrutiny. Barriers that prevent women from enjoying full and equal citizenship it was held, must be dismantled as opposed to being cited validate an unjust status quo. In National Legal Service Authority versus Union of India, this court recognized how the patterns of discrimination and disadvantage faced by the transgender community and enumerated a series of remedial measures that can be taken for their empowerment. In Jija Ghosh versus Union of India,
The discrimination aspect will not.
Well,
I'm not very convinced about this.
Well,
I'll look into it, but like I'm not very.
Because
how you are
so far as the proportionality theory under Article 14 is concerned, my lord, that this action
of the state has to pass the proportionality theory, my lord, under Article 14. And if it is found, my lord, that it is violative of Article 14, my lord, then I cannot be subject to investigation at three different forums, my lord. Because the state has already initiated an action of sending the Rongia police station case to Dispur, although there were no training centers, there were no other factors which were there so far as the Rongia police station being transferred to Dispur is concerned.
Why it has been done?
My lord, because after investigation,
What is your grievance? Why it has been done?
my lord, there are two things, my lord.
Why?
Once Dispur police station investigated the case, 41A was issued. I joined investigation. My statement was recorded. 91 was served upon me. I submitted 16,000 pages of document, all details before the Dispur police station. Now, my lord, Dispur police station, I've annexed all those documents, not those submitted documents. Now, my lord, Dispur police station, after making a threadbare investigation, came to a finding that no, we are transferring this case to Rongia. Well and good, my lord. The case was transferred to Rongia because we thought, my lord, yes, maybe that may be a correct approach because the complainants and the training center were in Rongia.
Have you challenged that?
My lord,
Have you challenged that, the transferring of your case to Dispur from Rongia?
my lord, subsequently, again, this is the subject matter of challenge, my lord. Again, my lord,
This
it
is
has
not,
been
this is how it
retransferred.
can be. This is not.
My lord,
Have you challenged that order of transferring the case from Dispur to Rongia without any reasons?
my lord,
Why did you challenge that?
my lord, so far as this is the grievance, my lord, which has been raised in this writ petition.
No, this case is different, Mr. Das. I mean, why
I'm
didn't
only
you
on
challenge
facts.
that? If you agree by that, why didn't you challenge that?
I'm not aggrieved, my lord. I'm not aggrieved by that.
You are saying the discrimination is happening.
No, my lord, discrimination qua Dhula and Tihu police station case, my lord. Because the same yardstick has to be applied in all similarly situated
So you are fine with your case,
cases.
transfer of case from Dispur to Rongia.
My lord, from Dispur
And
to
again, Rongia to Dispur, you are fine with that.
my lord, it has to be under one police station, my lord. That is my whole and soul. My
Tell me
lord,
whether
grievance
you are
is
fine with that
the
or not.
nature of documents and the nature of allegations which are involved in this case, my lord. Suppose, my lord, there are 4 different investigations carried out at 4 different police stations. Well, there can be conflicting opinions by the IO. So, my lord, all the more reason, my lord, if the entire investigation is brought in one single umbrella, in fact, my lord, I have
till this, it is fine. Your argument, you keep your argument simple, it is fine. But when you go to discrimination, when you go to equality, when you go to this thing, see, don't try to argue certain finer things unnecessarily. Those are not required. You keep your argument simple, that there is sameness in the case and the cases to be clubbed together. That should be your argument. Now, if you want to say discrimination, Article 14, this and that, those finer things, you'll get opportunity to argue all those things. You are a young person, you will get opportunity, a lot of opportunities you'll get to argue all those finer things of constitution. But each and every case, don't try to pull those things. That's what I'm saying. Okay. So you keep your argument simple. That there is a sameness in all the affairs, so affairs should be clubbed together. That should be your argument. And you have brought in the case laws that you have referred to. That's perfectly fine. But now you are bringing in so many other things. Those are not required. Those are not involved in this case. We are concluding this. Heard Mr. S. Das, the learned counsel, appearing for the petitioner. Also heard Mr. D. Nath, the learned senior government advocate for the state respondent. Hearing concluded, judgment reserved.
Respect, I want to mention item 46 of PADA. Not possible.
46, I'll have to release it, madam. Because problem is that I will not be here for next 2 weeks.
Okay.
So 1 month time.
Release and fix it, madam.
I'll just release it and fix it in the next week.
Next Tuesday or Thursday.
Okay. The item number I reduce.
Already in our case. Well, in our case, I have the case diary, all 4 case diaries I have. Right, so like take it to.
Case that you keep it with you, but if required, I'll take it from you, huh?
Lot.
If required.
Lot.
Around 18
Third, MS Pen Saikya, the learned counsel appearing for the petitioner. Mr. Saikya submits that the matter should be.
Next Thursday,
Matter should be listed on. When do you want, madam?
18 next Thursday.
Should be listed on 18th. However, it is seen that the was kept part, but this pens will not be available in the next week. In view of the apostle, the matter is released from the partner and let the matter be listed on 18th.
I'm like. Milo is taking over it. Milo is taking up the admission.
No, I don't think today it will be time.
In that case, my lord, I pay to mention item 19, the admissions column.
How many matters are there? Serially, Marita. We'll give the dates.
My opinion, Lordship. During the pendency of this criminal revision petition, Lordship, we have already paid the amount. We have settled for.
We have settled it.
Yes, Lordship.
So we will then we withdraw this.
Conviction may be set aside, Lordship. We have been convicted under section 138 of NI Act, Lordship. And compensation amount was fixed on 15 lakh rupees, and we have settled in an agreement, Lordship.
Where is that agreement?
Agreement, copy of this agreement is. Have the photocopy, Lord.
How much money you paid?
13 lakhs, Lordship. 13 lakhs, Lordship.
13 lakhs altogether.
It is settled only on 13 lakhs.
One time settlement.
One time.
You are Mr.
KK Hendrik, Lordship.
Heard Mr. KK Hendrik, the learned counsel is hearing for the petition. Also heard Mr. SD, the learned counsel appearing for the sole respondent. Sole respondent. This is an application filed under section 497 and 401 of CRPC. Rate with section 482 of CRPC 1973. Challenging the interim judgment out of 2022-4 passed by the learned additional session judge on a personal thoroughly in criminal appeal case number 4 in bracket S-4 bracket conflict stroke 2021. Hereby affirmed the judgment and order dated 29/9/2021 passed by the learned sub-divisional judicial magistrate in bracket M, personal thoroughly in CR case number 203/2014, whereby a petitioner was convicted under section 138 of NI Act. Where is the order? Convicted for how much? For what period? Conviction for?
6 months. Page number 33, Lordship. Paragraph. It is further directed that accused shall undergo simple imprisonment for another 3 months.
Whereby the
6 months.
petitioner was convicted under section 188 of NI Act for three months.
No, it's 6 months.
Where is 6?
Paragraph 44, Lordship. Considering the nature of the offense
Okay,
and the other.
Sentencing the petitioner to undergo simple imprisonment for a period of 6 months. 6 months. 6 months and further to pay compensation of rupees 15 lakhs only to the respondent number 2, as the check amount is of rupees 9 lakh. What is this 9,11,000?
It was the same amount. These are not check amount.
Okay, 9,11,000 9,11,000 only, as about 6 years have elapsed from the date of issuance of the check. It was further directed that the accused shall undergo simple imprisonment for another 3 months in default of payment of compensation. Full stop. The learned counsel appearing for the petitioner submits that during the pendency of the instant revision petition, and out of court settlement has been arrived between the petitioner and the respondent, the sole respondent, whereby uh, uh, whereby they have executed, whereby the parties have executed a deed of agreement dated 5/6/2025. Full stop. It is stated that by the proceed agreement, the petitioner has already paid how much money?
13 lakhs.
The petitioner has already paid rupees 13 lakhs as one-time settlement for the dues, as well as the amount mentioned in the order dated 22, order dated 29/9/2021. 21. The learned counsel appearing for the petitioner has submitted the aforesaid deed of agreement dated 5th June 2024. The same is kept on record by marking X. In view of the aforesaid out of the court settlement, the learned counsel appearing for the parties submit that the instant that nothing survives in the instant case, and the instant case should be closed. Full stop. In view of the aforesaid submission and taking into account the deed of agreement dated 5th June 2025, the instant revision petition is closed and disposed of. We'll close it. Close and disposed of by setting aside the order, judgment and order dated 22/4/2024. 22/4/2024, passed by the learned additional session judge Vishwanath Chareli, as well as the order dated 29/9/2021, passed by the learned SDJM
Within bracket M.
Vishwanath Chareli. In the above terms, the instant criminal revision petition is disposed. That will do. Joe, when do you want?
My lord, in this matter, I've been told that the CD has not been received.
CD hasn't come.
No.
CD is awaited. Later matter will listed in the.
My lord,
later matter will
for 2 weeks. My lord, could it be on Monday? He is agreeable to Monday, my lord.
Let it be after 2 weeks. There is no urgency. He give me other.
Obliged.
Finally, your lordship. Lordship, regarding item number 49 in the hearing column. Lordship, the arguing counsel had to leave the court premises due to some personal difficulties.
Okay, on the prayer of the learned counsel, item number 49. You are appearing for the petitioner.
Appellant.
On the prayer of the learned counsel, appearing for the appellant, let the matter will listed after 2 weeks. After 2 weeks. Please. When do you want? Can you show 15 or 16 lot? 15, 16 100%. On the joint prayer of the learned counsel, appearing for the parties, with the matter will listed on 24th 24 to plus. Published.
Chip, may please look. There is an IA for suspension.
So we'll not take up to date only postpone.
Any date before we.
Okay, may how Mr. They are clear that the council paid for that. So see for the next one. Later matter will be listed on 24th of
Public.
Lordship, they have to provide the instruction regarding service upon the informant.
Not fixing good.
POCSO case.
You find out, Mr. Das, what is happening, POCSO matter.
Not.
Whatever is B statement, legal aid counsel appearing for the applicant also what Mr. TP as the learned APP for the script. Service on respondent number 2 is yet to be completed. Mr. The learned APP is direct to get the status of service of notice on respondent number 2 and intimate this for the next date of listing. Data might be listed on 25th of March. When do you want?
After vacation.
After vacation. On the prayer of Mr. Yeah, you came Hassan, right?
Yes, ma'am.
Came the prayer of Mr. Some topic. Later matter be listed after the entry. Some. Non appeared when the matter was about for listed after